to get my.
Because she takes a few minutes too to like
Yeah,
get
yeah.
her own, like get it all worked out. And previously it was always a question, who's doing it? Is it Anna or the IT guys? But we settled finally, Anna will be the one doing it just so there's some accountability and she knows when the hearings are coming.
Got it. All right, I need to print this. Why is it not letting me print it?
All right, so if you're good, I'm gonna just drop off and
Yeah, I'm good.
come back in like 10 minutes.
Sounds good.
Cool. Hey, Jocelyn,
Yes.
can you make me a co-host? And the reason I say for you to do that is because if you're going to be reading, if you're going to be sort of conducting the hearing, it's very frequent. You won't be looking over the participant box, and then stuff will happen that I can let people in. Someone's computer shuts off, and then they're like, it's locked out, and they'll send you an
Where?
email. I'm stuck out.
Uh,
This kind of thing.
uh, how do I do that? Do you know?
On the bottom there, it should be in participants, I think, on that
Participants.
little caret thingy, maybe.
Yep. Christopher Ryan.
And if not, maybe it's if you just hover over in my participants in the participants area where I am, and then those three dots, that might be where it is.
Make co-host.
There you go.
Gotcha.
Because presently I can't see who's in the waiting room. Now I
Okay.
can, once I'm the co-host.
That's great.
Yeah, and
Done.
that's pretty common. Like you'll see people just get someone's computer freezes and like I got to reboot, and they're like stuck in the waiting room, and they email us, and like you're doing too much other stuff to worry about that. So
Okay.
how's it going, Melissa?
Very well. How's it going for you? Oh, geez, touch something and you disappear.
Pretty good. It's hot here. You're in where? You're in Arizona, right?
Oh yeah, it's hot here.
What's the temp?
You know, they've got a heat warning, so it's probably over 110.
Oh my goodness.
It's like 90, right? Right. I get up and walk in the morning at 5
Yeah.
because it's still a little cool. A little cool.
Do you so is that in the Phoenix area where you live?
I live in a place called Awatuki, which is kind of South Phoenix. I don't know if you know Phoenix very well, but it's borders the East Valley, which is
Okay. I don't know
Chandler.
very much. I just figured like if it was that hot, that's I mean all of Arizona is like I mean I guess no, Flagstaff, I've been there. That's could have been slightly different, more like kind of New Mexico type climate, I thought anyway.
Yeah, it is.
Higher
It,
elevation, right?
yeah, much. And I have you drive 1 hour outside of Phoenix and you start getting up in the mountains. I have a home in Pine, Arizona, and it's got pines and
Yep.
it's on the rim there, and it's much cooler in the summer.
Then I just had family friends who lived in Prescott, and that was
Yes.
like kind of that I think that seems more like the Rockies was they were trying to convince me is more the case.
I don't think it looks like the Rockies. I used to live in Salt Lake City, so but
Okay.
it's our version. I mean, it's beautiful. You wouldn't think, you think high desert, but even Salt Lake City is considered high desert with
Yeah,
mountains.
right.
Yeah, it's yeah.
Cool.
Yeah. It's definitely our summer has started. It'll last till October now.
My goodness.
It's long. It's a long season. But that I always say to people, that's why I live indoors.
Uh, should I admit everybody since it's just a couple minutes until 9, or just wait until 9 o'clock?
Ah, you can just put them in. It's fine. They'll sit there getting all their stuff, make sure it works. That always takes them a few minutes.
Yeah, I kind of need to know who's going to be actually here as opposed to I've got all these attorney names and I don't know some of them.
That's good to know. Thank you, Melissa. I didn't realize that, so there we go. Well, now we know something new.
Yeah, I like to cull things. Let's see. I want to put this on gallery view though.
Uh, I may officially have too many screens.
No such thing.
I should have come in on Friday, messed around with them, get a better sense.
I want a Bloomberg panel. That's what I want. I want the full functionality of like advanced capitalism.
All right. keep an eye on the waiting room?
Yep.
Okay. All right. Good morning. Can everyone hear me all right? All right. Good morning, everyone. My name is Jocelyn Barrett. I'm a hearing examiner with the New Mexico PRC. The time is 9 a.m. and we are now on the record. The matter before the PRC this morning is the evidentiary hearing in the matter of Southwestern Public Service Company's application for its annual 2026 Renewable Energy Portfolio Procurement Plan. The case has been docketed as case number 25-00027 UT. I'm joined today by my co-hearing examiner, Christopher Ryan. We will be presiding over this hearing and ultimately providing the commission with a recommended decision in this matter. The hearing today is being transcribed by our court reporter, Ms. Gonzalez, and also being live streamed on YouTube. Any witnesses should follow along on the YouTube stream until it's time for their testimony, at which point either hearing examiner Ryan or I will admit them into the Zoom. And for the sake of the record, I'd like to start with entries of appearance. Let's start with SPS.
Good morning, hearing examiners. Dana Hardy on behalf of SPS, and Patrick Pearsall is also appearing for SPS.
Good morning.
Good
OPL.
morning.
Good morning, Your Honor. Michael McMillan for OPL.
Good morning. New Mexico Department of Justice.
Good morning, Madam Hearing Examiner Gideon Elliott for the NMDOJ.
Good morning, Mr. Elliott. CCAE.
Morning, hearing examiner Kara Lynch with Coalition for Clean Affordable Energy.
Good morning. New Mexico Large Customer Group.
Good morning, hearing examiners. Nick Stoffel with the law firm of Holland and Hart, appearing on behalf of the NMLCG. I'd like to enter the appearance of my colleague, Seamus Crowley, as well.
Good morning, gentlemen. LES.
Hi, good morning. This is Joan Drake on behalf of LES, and I want to note that my partner, Susan Miller, will be appearing for LES tomorrow.
Thank you.
Thank you.
And NMPRC staff.
Good morning, hearing examiners. Renee Moise appearing on behalf of New Mexico Public Regulation staff. And also appearing with me this morning is Katie Lang, who will be handling the direct examination of staff witnesses.
I'm not seeing Miss Lang. Is she just not on my screen? Or is she here, or is she going to be joining us later?
She was a moment ago. She might have dropped out momentarily.
Okay.
I will keep my eyes on the waiting room, let her in.
Great. All right. I'll note for the record that there were no individuals who signed up for public comment for this hearing. And a few housekeeping matters. I received an email from Ms. Lynch asking to be excused. Ms. Lynch, for the record, could you restate your request?
Yes, I'm requesting to be excused from 2:30 to 5, assuming that's the duration. Back tomorrow if this continues. But I had a scheduling conflict. I waived cross-examination for that time period and also will not include any of that matter in a post-hearing brief.
Okay, thank you. That request is granted.
Thank you.
You're welcome. Are there any other parties who wish to be excused at any point?
Madam Hearing Examiner, tomorrow morning, Ms. Reno will not be available from 9 to 10, but during that period of time, I'd ask that I be excused from 9 to 10:15, as it may be.
Sure, that shouldn't be a problem. That request is granted. Anybody else? Ms. Drake?
Yes, as I noted, Ms. Miller will be appearing for LES tomorrow, so I would ask to be excused, at least in the morning. Hopefully we won't go beyond that, but I might not be able to be here tomorrow.
Okay, and that's fine.
Thank you.
Wanted to comment on one thing. I think when we should have more dialogue about these matters, I won't say too much about all this, but like from my perspective, and hearing Examiner Barrett, we don't have to discuss this in any detail this time, but like, I think you all, our sense of attorneys and how we function in the world as attorneys, we are necessarily multitaskers. You have to do all these different things all the time. From my perspective, if you all can't make hearings, it's perfectly acceptable. I don't expect you to have your screens on. I expect you to be doing other work because we're all super busy. And I mean, to my view, it doesn't even matter that you don't let us know you're not coming. Our rules make very clear what is the consequence of not appearing. So I guess what I'm trying to say is I understand the need to be multiple places simultaneously and would never expect folks to stick around and participate if they don't really have anything to participate in.
Okay, thank you. And I echo what hearing examiner Ryan said. I know some hearing examiners require that you have your screen on at all times, but I don't think we really care. Let's see, are there any other, anyone else who wants to be excused or anyone else who is waiving cross-examination in this matter?
Madam
Great.
Examiner, Dina Hardy for SPS. SPS does waive cross-examination for the witnesses of staff and the interveners, but reserves the right to ask follow-up questions as appropriate.
Staff and all of the interveners?
Correct.
Okay,
Thank you.
you're welcome.
Wait, so let me make sure I understood that. Ms. Hardy, you're waiving the request for cross of any of the witnesses, but are requesting to the extent to which, I mean, you're redirected, or you're referring to questions rising as a consequence of the questions myself and hearing examiner Barrett wish to ask?
That's correct. Follow-up questions to questions asked by your honors or other counsel if there are any.
Okay, I just wanted to be clear.
Yes, thank you.
So we sent out an email last week about a proposed order of witnesses, and I received 2 responses, one of which was from staff just asking to switch the order of their witnesses, which is fine. And the second, as Mr. Elliott said, Ms. Reno will not be available tomorrow morning. I think it's likely she'll testify this afternoon, but in the interest of making sure, OPL, would you be willing to switch the order of witnesses so that Ms. Reno could testify right after SPS's witness, and then Mr. Lee would go right after her?
I believe that works for OPL, yes.
Okay, and is that okay, Mr. Elliott? You're still muted.
Sorry, thank you. I believe that would work for Ms. Reno. I'm gonna contact her now.
Okay, and if
you,
for
Ms.
some
Reno.
reason the SPS witnesses are going quite long, then we can revisit this issue later in the afternoon if we need to move her up or do something else. All right. As of now, we haven't felt it's necessary to impose any time restrictions on cross-examination, but hearing examiner Ryan and I do reserve the right to impose those limitations if we feel it's necessary as we go along. We're going to take a morning break around 10:30, an hour or so for lunch, and then at least one break this afternoon. Anybody is welcome to request a break at any time if they need it, as long as it's not between a question and an answer. And feel free to let me know if that is necessary. Are there any other preliminary matters that I have not addressed? Ms. Drake?
Yes, as I noted in my email to you, Mr. Gorman is not available today, but he is available tomorrow. So we requested if he could be scheduled for tomorrow.
Oh, I'm sorry, I forgot that one. The only reason I could see that as an issue is if we go quite a bit shorter than I was expecting to. But again, as of right now, I don't see why that would be an issue. And if we need to, we'll revisit it later in the day if things do not seem to be proceeding the way that we're expecting them to. Is that okay?
Yeah, that's fine. Thank you. And if nobody has questions for him, I would request that he be excused, but I'm not sure if your honors have questions for him. So I'm happy if we revisit that in the afternoon.
Okay, and that'll be what we'll plan to do.
Great.
Hearing examiner Ryan and I will check in with each other about whether we have questions for Mr. Gorman, and we'll let you know, because if he could be excused, then there's no reason for him to be hanging around.
Great, thank you.
You're welcome. Anybody else?
Your Honors, I have a couple of preliminary matters I wanted to mention. One is that we did submit last evening a correction to Ms. Trammell's testimony, and that was uploaded to the Dropbox, and I believe everyone should have that. And then the second matter is that under the Commission's order granting SPS's variance petition, we will file our RPS report along with supplemental testimony on July 1st. And so I was going to request that the record remain open for the inclusion of those items when they are filed.
I don't think that should be a problem. Hearing examiner Ryan?
This Hardy, if you could, and this may have been explained in the testimony of the application, I just don't recall. But why was the variance necessary? How did that process work out the way that it did?
Sure. Your Honor, the variance petition was granted to allow SPS to proceed with filing its RPS application, in this case, early, so that we can have a decision prior to filing our next rate case. So we know how the Commission wants to treat cost recovery. So we filed our application and our REA plan early in accordance with the order granting the petition, but the report would not be ready until July 1st because of the information that needs to be included in it. It wasn't available early at the time we filed the application. So that's the reason for the two filing dates.
Great. I'm remembering that, reading about that in the testimony now too. So thank you.
Yeah, thank you. And we'll go ahead and do that.
Thank you.
Is there anybody else? So just to remind everyone, the order of cross-examination will be, well, for the SPS witnesses will be OPL, NMDOJ, CCAE, if Ms. Lynch has questions, New Mexico Large Customer Group, LES, and then lastly will be staff. And if there's nothing else to discuss, we can go ahead and have SPS call their first witness. Anything else? All right, let's go ahead.
Thank you. SPS's first witness is Ms. Brooke Trammell.
Thank you. And will the court reporter please swear in the witness?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good morning, Ms. Trammell.
Good morning.
Can you please state your name for the record?
My name is Brooke Trammell.
By whom are you employed and in what capacity?
I am employed by Southwestern Public Service Company as Regional Vice President, Regulatory and Pricing.
Do you have a document in front of you that's been marked as SPS Exhibit 1?
I do.
And can you identify that document, please?
This is my direct testimony in this proceeding filed April 1st, 2025.
And does it include the attachments to your testimony?
Yes, it does.
And does the testimony include a correction that you identified?
Yes, that correction was made on page 27 and is reflected in my copy.
And are the testimony with the correction and the attachments true and correct?
Yes, they are.
If I asked you the questions in your direct testimony today, would your answers be the same?
Yes, they would.
Hearing examiners, I move the admission of SPS Exhibit 1.
Thank you. And Ms. Hardy, is the corrected testimony that was uploaded to Dropbox, is it redlined where the
Well, I
correction
was
is?
just going to ask, I had the same question. I'm looking at it now and I don't see any correction on page 27.
I believe it is redlined.
Is it 27, Ms. Trammell? Is it a different page perhaps?
Yes, Your Honor, it should be page 27. It was redlined and it should show the strike through of the language we removed. And then the additional language is literally in red text on my copy.
Let's do this.
Lines 14 through 16 on page 27.
It's page 33 of the PDF, page 20
Okay.
of the document.
I'm sorry, please repeat that.
It's page 33 of the PDF and page 27 of the testimony.
Page 33 of the PDF. You guys are seeing what I'm seeing?
It looks like that's not the corrected version, though.
That's
Yeah, I
correct.
know.
That's not the corrected version.
Was it uploaded? Well, let me go back to
It was
Dropbox.
uploaded last night, so it would be dated the 15th as opposed to the 13th.
I see. Okay.
Yes.
So it's there?
Yes.
Cool.
All right. Any objections to the admission of Exhibit 1? Hearing none, Exhibit 1 is admitted. Please go ahead, Ms. Hardy.
Thank you. Ms. Tremmel, do you have a document in front of you that's marked as SPS Exhibit 2?
I do. This is my rebuttal testimony in this proceeding filed June 4th, 2025.
And are there any attachments?
No, there are no attachments to my rebuttal.
Is the testimony true and correct?
Yes, it is.
If I asked you the questions in your rebuttal testimony today, would your answers be the same?
Yes, they would.
Hearing examiners, I move the admission of SPS Exhibit 2.
Any objections to the admission of SPS Exhibit 2? Hearing no objections, SPS Exhibit 2 is admitted.
Thank you. I have no further questions for Ms. Trammell. She's available for cross-examination.
Great, thank you. Does OPL have any questions for this witness?
Yes, Your Honor.
All right, please proceed.
Good morning, Ms. Trammell. My name is Michael McMillan. We've met before. How are you today?
Good morning. Great. Good to see you.
So one of the rate-making treatments that SPS is requesting in this case is SPS wants to put the cost of the self-build solar facilities into rates through its RPS rider, correct?
That's correct.
And the purpose of the RPS rider is to reflect the cost of compliance with New Mexico's RPS mandates, correct?
Yes.
And would you agree with me that the Commission established SPS's RPS rider in particular to capture all of SPS's incremental RPS costs in one recovery mechanism?
I agree that the 2012 rate case had specific language about the rider that was authorized, and SPS in this proceeding is requesting the Commission to allow recovery of the self-build revenue requirements.
Okay, well, I want to talk a little bit about what incremental means in this context. Incremental RPS costs means in this context.
Okay.
I'd like to use the SunEd PPAs, SPS's SunEd PPAs as an example. Are you aware of what I'm talking about?
When you say this context, are you talking about SPS's requests in this proceeding or the context of the 350, the 2012 rate case?
In the context of the RPS, what an incremental cost would mean. So not limited necessarily to this proceeding, but just generally what incremental costs means is the concept that I'm going for. But we'll get there in a second. You're aware of the SunEd PPAs, correct?
Yes.
And those are solar PPAs that SPS entered into a few years ago, correct?
I think it's been a number of years. I don't recall the effective date of those PPAs.
But you'll agree they've been in effect for several years, correct?
Yes.
Okay, and the costs associated with the SunEd solar PPAs, they're not all flowed through the RPS rider, are they?
No, the economic energy costs under the PPAs go through the fuel factors.
Can I interject for a moment, please, and ask? So this is a question I think is important, so that and I apologize, Mr. McMillan. I just want to make sure I understand. Can you describe, Ms. Trammell, when you use the word economic costs? Am I to presume that there are and then again, my understanding is this maybe perhaps comes out of former commission cases, uneconomic costs, and just give me some background so that I better understand when you say that the economic costs, what are you referring to?
Sure, thank you for the question, Your Honor. In the 2012 rate case, SPS's rate case 12-00350, I believe it was, there were particular discussions around economic versus uneconomic costs, particularly with these SunEdison PPAs. At that time, the commission determined that economic costs were costs of that PPA or those PPAs below SPS's system avoided costs, and costs above that were uneconomic costs. So that avoided cost calculation sets the threshold, if you will, for evaluation of economic versus uneconomic costs in the SunEdison PPAs. And that's why I said the context of that case versus now.
Let me make sure I understand you. So an economic cost would be where the actual cost to the ratepayers would be, I mean, within below the system average. I mean, effectively, you're trying to understand whether it's an efficient expense. Is that the idea?
Essentially, and it's not system average fuel costs. It's a system avoided cost. That is the kind of inflection point between economic and uneconomic. All of the costs of the PPAs are recovered from SPS New Mexico retail customers. That economic versus uneconomic designation affects which mechanism it goes through and which portion is direct assigned to New Mexico.
Is it the case, is SPS's position here that sort of breakdown is still useful and should be adhered to?
It's SPS's position that that framework is useful for the designation of economic and non-economic costs under those SunEdison PPAs. That framework is not the definition of costs recovered through the rider. That's SPS's position from the 350 case. And with respect to the self-build renewables, the request in this case, it's SPS's position that that uneconomic versus economic calculation is essentially inapplicable. It's very specific to the SunE contracts, but not the solar projects. Not the SPS owned, I should clarify, solar projects.
So, and is that the case because the company's position is effectively that the legislature, by passing the rider, effectively granted you all the discretion, or at least the commission can exercise discretion to allow you to collect all costs for RECs used for RPS purposes through the rider? It's sort of like there's a broader principle that sort of wipes out the economic, uneconomic. Is that the idea?
The economic, uneconomic is more applicable to those PPAs, but the statute does allow for self-build recovery through the rider mechanism. I think if we could take a step back, maybe go up 100,000 feet, when we're looking at an avoided cost comparison, and especially historically, when SPS did not have the level of renewable penetration that it has on the system today, renewable resources procured solely for RPS compliance could be thought of as displacing other generation on the system, right? So if there wasn't a need necessarily for the incremental renewables, renewables were added only for RPS compliance. So those additional, that additional generation was offsetting other generation on the system or generation that would be procured from the marketplace once SPS entered the IM. So what we're seeing today is a need for new generation on our system, additional generation, and that's driven by load growth. That's driven by SPS's requirement to serve increasing sales and capacity on our system. So we're no longer in a place where we're procuring incremental renewables and displacing system generation. We're needing to procure additional generation sources to meet load and retire RECs from renewable facilities for RPS compliance. So what I tried to characterize in my rebuttal testimony was that the circumstances today for incremental renewables are quite different than what they looked like in 2010, 2012, when the rider was initially approved for SPS.
Do you see a circumstance, and I'm sorry to do this, but I'm just going to jump right all the way to sort of my thought, and I didn't mean to hijack Mr. McMillan's questioning. I'm just sort of chomping at the bit here to jump into a circumstance in which all costs for generation run through RPS rider.
It is
Like-
SPS's position that the legislature intended for the RPS rider to demonstrate and clearly show to customers the costs of RPS compliance. So to the extent a resource is procured or built for RPS compliance, if RECs are retired for RPS compliance for those facilities, it's our understanding that the legislature intended that presentation of cost to be made available to customers through use of the RPS rider.
So even if you're to serve the New Mexico jurisdiction, your company, and that may not be quite, I'm thinking Excel is a broader company, I would say multiple service territories, but to the extent to which you're providing service in New Mexico, and that has to be 100% renewable based, do you see a circumstance where basically all costs are going through the rider and like base rates are sort of somehow gone or something?
Well, base rates would not go away because the RPS rider only recovers the cost of generation. So we have a number of other functional revenue requirements that would still be in base rates. But for all renewable projects on the system that have renewable attributes or renewable energy credits retired for RPS compliance, yes, we see those going through the RPS rider, so long as they're being retired for RPS compliance in a particular plan year. And I think that's where the dynamic of these proceedings come into play, because SPS clearly needs to demonstrate that they will be retiring or otherwise banking RECs from those facilities for RPS compliance in a particular plan year.
Thank you, Mr. McMillan, back to you, sir, sorry.
So I think we actually covered there quite a bit of what I was just going to talk about with the SunEd PPAs. But Ms. Trammell, I wanted to follow up on one thing that you just said. You mentioned that it's SPS's position that the legislature intended for the RPS rider to include all RPS compliance costs. Is that a correct characterization?
Yes.
What about Hale and Sagamore? I mean, aren't those renewable generation facilities that SPS already has that are not recovered through the RPS rider?
That's true, and I believe those to be an outlier in this conversation. Hale and Sagamore facilities were proposed as economic projects. They weren't needed for system generation at the time, but their proposal was the addition of that infrastructure could offset existing fuel costs on the system. The Commission reviewed those projects in a CCN and they were approved on an economic basis. That CCN was resolved by settlement, which the Commission ultimately approved. And the settlement provision in that CCN case outlined the recovery framework for the revenue requirement of those company-owned renewable facilities. SPS approached the CCN seeking a recovery determination for the solar projects, but the Commission declined to make those cost recovery determinations in the CCN for the SPS solar projects like they did for the SPS wind projects. And of course, also the solar CCNs were not resolved by way of a settlement agreement that included a rate-making determination.
Okay, so I wasn't really asking you to relate it to this case, but just about Hale and Sagamore. Hale and Sagamore, those are SPS-owned generation facilities. They're wind facilities that the costs of which are not flowed through SPS's RPS rider. Is that correct?
That's correct.
Okay, and you said that you believe it's the legislature's intention that all RPS compliance costs flow through the rider, and you linked that to I think you said anything that is producing RECs that are then retired for RPS compliance purposes. Is that right?
Retired or banked.
Okay, the economic portion of the SunEd PPAs that we were just talking about, you guys bank and or retire those RECs for RPS compliance, right?
Yes.
Okay. So I'm scrolling down to get past the portion of my cross that that we've already covered. Give me just a moment. Okay, so in this case, Ms. Trammell, SPS proposed the self-build solar facilities to satisfy a capacity need, correct?
Initially, yes.
So you did propose them to satisfy a capacity need?
Yes. They were a component of the overall portfolio to address a capacity need identified in 2022.
Okay, and the self-build solar facilities, the RFP or request for proposals process for that was an all source RFP, is that right?
It was.
Okay, and an all source RFP, that means it was technology neutral, correct?
We say technology agnostic. In other words, the generation technology selected is not predetermined.
And it was also ownership agnostic, right? Like it could have
That's
been
correct.
PPAs, could have been self-build.
I'm sorry, I missed that question. It was also,
And it was also ownership agnostic was the question.
That's correct.
Okay, and what that means is that it could have been a PPA with a non-utility owned facility or a self-build facility like these, right?
Or a build own transfer under the options of the RFP, but technically, yes, developer owned or company owned.
Okay, so in that all source RFP process, if there had been a proposal that involved SPS acquiring non-renewable resources that would have satisfied the projected capacity need at a significantly lower cost, it's likely that SPS would have selected that proposal instead of the self-build solar facilities, right?
I'm going to offer a general statement, Mr. McMillan, and then a specific statement to answer your question fully. The portfolio selected included multiple projects, and the portfolio is the most cost-effective and reliable solution of the bids received. There were additional projects other than just the solar projects selected in that portfolio, including projects that are not eligible for RPS compliance, like at this time, battery energy storage facilities, as well as a gas PPA.
Gotcha. So that's helpful clarification for me. Let me amend my question. So during that RFP process, if there had been a portfolio of resources that did not include any renewable generation, but would have satisfied SPS's projected capacity need at a significantly lower cost, it's likely that SPS would have selected that other proposal instead of the one that included the self-build solar facilities, correct?
In that hypothetical, it would also depend on the company's RPS position in what we refer to as the resource acquisition period. So all else equal, if SPS in that hypothetical did not have a need for RPS compliance or additional renewable resources specifically for New Mexico, yes, I would agree the hypothetical you described could have played out. If the resource acquisition period had needed RECs for RPS compliance, a New Mexico specific portfolio would have included renewables to meet RPS compliance. So what happened in 2022 was the capacity resources were selected for a time period when SPS had, if you go back to 25, where we were ahead of RPS compliance requirements. But these projects, the solar projects, do contribute to compliance in 26 and 27, which were years in the resource acquisition period for that RFP.
Well, in the CCM proceeding for the self-build solar facilities, and I believe also the battery facility that you mentioned, you did testify that those resources were being proposed solely for capacity. Is that correct?
They were selected in the portfolio based on their capacity need. That was a capacity RFP. they also contribute to RPS compliance, but the CCN need was initially capacity.
Gotcha. So I want to get some clarity on when SPS thinks it would be appropriate to flow the cost of renewable energy facilities through the RPS rider. So to do that, I'm going to set up a hypothetical and we're going to set it up and I'll make sure that we're on the same page. Are you with me?
Yes.
Okay, so hypothetically, let's say that SPS has a projected capacity shortfall a few years into the future. In that scenario, SPS is obligated to acquire sufficient capacity to resolve the projected shortfall, correct?
Yes, on a system basis.
Okay,
The resource adequacy requirement you described would be a system resource adequacy requirement, Texas and New Mexico.
and that resource adequacy requirement that exists independently of SPS's RPS obligations, is that right?
That's a fair characterization.
Okay, and if SPS is faced with a capacity shortfall, like we talked about before, one way that it can acquire additional capacity is by building its own facilities, correct?
Yes, we're bypassing in your hypothetical the solicitation requirements under New Mexico IRP rules, but yes.
Okay, so let's set up the meat of the hypothetical here now. So let's say SPS determines that the most economically efficient way to resolve its capacity shortfall is to self-build a 1 gigawatt wind farm. Are you with me on that hypothetical?
Yes.
Okay, and let's say hypothetically SPS went to the commission, explained that capacity shortfall, and got a CCN authorizing it to build that 1 gigawatt wind farm. Are you with me?
Yes.
Okay, so I'm going to present a couple of scenarios to see how that interacts with the RPS in your mind or in SPS's position. Okay, so in the scenario I set up, let's say that SPS is just leaps and bounds ahead of its RPS targets. So the existing portfolio will provide SPS with enough RECs to comply for the for the entire service life of that new 1 gigawatt wind farm. Are you with me on that hypothetical?
Yes, that would be an amazing position to be in.
I agree with you that if only we lived in that world. But so we have SPS is going to build a 1 gigawatt wind farm, but they're so far ahead on RPS that they're going to have enough RECs with their existing portfolio to comply for the entire service life. Now, in that scenario, do you believe that SPS would be able to flow the cost of that hypothetical 1 gigawatt wind farm through the RPS record?
May I ask a clarifying question?
Sure.
I know it's not supposed to work this direction, but in your hypothetical, when you say that essentially is RPS sufficient, you mean from a current year retirement, future year retirement, and any particular banking window, which I understand in New Mexico rules is that 4-year piece. So you mean deficiency or sufficiency in any of those scenarios?
Yes.
Great. Yes, to the extent RECs are not retired from that facility for RPS compliance, it is SPS's position that the revenue requirement for that facility would not be recovered through the RPS rider.
Okay, so let's go to scenario 2. So in scenario 2, let's say SPS is ahead of its RPS targets, but not by quite such a ridiculous amount. So in scenario 2, SPS's existing portfolio will provide it with enough RECs to comply for, let's say, the next 5 years. But then after 5 years, they would have to start retiring RECs from our hypothetical 1 gigawatt wind farm. Are you with me on that hypothetical?
Retire or bank, just to simplify those two together. Does that work?
Yes, that works. Are you with me on that?
Yes.
Okay, so in that scenario, do you believe SPS would be able to flow the entire cost of that 1 gigawatt wind farm through the RPS rider?
Not initially, not in those 5 years. If the RPS sufficiency position was there from a retirement standpoint and a banked. In other words, if RECs from that 1 gigawatt wind facility were not used for RPS compliance, again, in your hypothetical, I believe you said the first 5 years of the service life, those would not be eligible for RPS recovery under SPS's proposal. Right of recovery would demonstrate costs of compliance. And so if the RECs are being banked or retired, then that would be the entry point, if you will, for RPS recovery.
Okay, so in that scenario, what SPS would theoretically do is put the wind farm into base rates and then transition it later to the rider. Is that the intention?
Yes, if the commission approved the recovery mechanism or that recovery framework consistent with SPS's proposal of RPS eligibility.
Okay. So Al, let's talk about my scenario 3 here. And
Actually, before you start your scenario 3, can I ask a quick question? I don't want to interrupt you when you start your new scenario. This has actually been very interesting and informative. So my question, Ms. Trammell, is to clarify the hypothetical wind farm would be added to the RPS rider only at the time when it is being used for RPS compliance. RECs are either being retired or banked from that facility. Am I understanding that correctly in this hypothetical?
Yes, Your Honor, you are.
Okay. So I guess my question is, where does that line get drawn? Because my understanding is in the CCN matter, the 2023 CCN matter, SPS was making the same request as it's making in this case. At that time, SPS was not certain that these facilities were going to be needed for RPS requirement. You were anticipating that they likely were going to. And my understanding, and correct me if I'm wrong, is between then and now, that has changed. And now you are certain that they will be required. So I guess my question is, under this hypothetical, why was SPS asking for this treatment in the CCN matter when at that time there wasn't a certainty that these facilities were going to be used?
Great question, and kind of 2 parts there. I'll try to address both. First, as I mentioned when we started the hypothetical conversation with Mr. McMillan, this is a very challenging hypothetical because it's actually probably the opposite direction that our compliance position would be. It assumes, we're way out in front of RPS compliance. And while SPS has been ahead of RPS compliance through the 2020 and 2025 requirements, given our sales growth trajectory, that's probably an unlikely scenario going forward. So it really kind of flips what the nature of compliance positions will likely be in the future. But to your question of the CCN proceeding versus now and the certainty of RPS compliance, we did not have the modeling for RPS compliance presented in that case. So from an evidentiary record perspective, we had not put forward an RPS plan in the CCN. We filed the CCN in July of 2023. That would have been putting forward a compliance position from RPS purposes for plan year 2026, well in advance of when those plans are usually put forward by the commission. Your honors understand that the RPS plan years presented the calendar year prior. So we would have been modeling a compliance position and seeking a determination from the commission on its plan year RPS compliant, on SPS's plan year RPS compliance position in the CCN, which is well in advance. A couple of years would have needed to be incorporated there from a sales and compliance and retirement position that was very difficult to be modeled at that time. So we anticipated, as you stated, that the RECs from the solar facilities would absolutely be needed for RPS compliance, but under the commission's RPS filing requirements, we needed to get a lot closer to the plan year to present that information and do it in the commission RPS proceeding rather than the CCN.
Okay, so then going forward, if SPS finds itself in a position again, as it did in the CCN proceeding, where they're anticipating, but they have not yet modeled, and you are not yet certain, are you anticipating that you would again attempt to use the RPS rider for that procurement from the beginning, or would you do something more like what you're talking to Mr. McMillan about, where you start off with that facility and base rates and then transition it at a point where the recs start being retired? And correct me if I'm misinterpreting something from the hypothetical.
Yeah, we've got a lot going on in the hypothetical.
It's a good hypothetical, but there's a lot. Yeah.
No, I appreciate the question. So generally speaking, the RPS requirements are increasing over time. And the next milestones are pretty material increases in RPS compliance. Those milestones would be difficult to achieve if SPS's load growth or sales requirements stayed flat over that horizon. But we see increasing sales growth on our service territory and from our customers. So that adds additional challenge, right? With sales being the real compliance factor for RPS compliance until the 2045 milestone, which is a zero carbon system essentially for New Mexico sales. So as we're kind of marching along on this renewable compliance trajectory, it is going to be harder and harder to comply without significant amounts of incremental renewable resources. So from a long-term resource planning process, right, the resource solicitation that we'll be undertaking through the Commission's IRP rules, we have multi-year resource acquisition periods, right? And that contrasts to the Commission's framework for essentially single-year RPS proceedings, right? Even the next plan year in an RPS proceeding is only presented for informational purposes. We're kind of doing RPS filings 1 year at a time, but we're doing long-term resource planning multiple years at a time in the IRP. So those two things do conflict a little. To your question of would SPS be presenting in a CCN renewables for essentially RPS compliance in the future, that's highly dependent on our RPS position in any of those given years. But generally, the anticipation would be that incremental renewable resources added through the integrated resource planning process, which again is going to seek first a system solution, the most reliable, most economic portfolio of resources to address system capacity and energy needs. That portfolio, again, all source, technology agnostic, if renewables are selected as part of those capacity expansion plans and are also selected to address energy adequacy on the system, they may also carry with them the benefit of renewable energy credits that can be banked or retired for RPS compliance. Now, if the system solution, that system portfolio, which in the IRP process we refer to as the multi-jurisdictional baseline, to the extent that portfolio is not RPS compliant, then incremental resources, incremental in the sense of they're above the resources selected in the multi-jurisdictional baseline, those would be identified in the long-term resource planning processes solely for the purpose of RPS compliance. So if a resource in a CCN was part of the multi-jurisdictional baseline versus part of, say, an RPS compliant portfolio, the presentation of the information could differ hypothetically in SPS's future. And it's a relatively lengthy answer, but it highlights the complexities of resource planning in New Mexico for capacity and energy adequacy, as well as compliance with RPS in two regulatory timeframes or processes that look at one a longer time period and one much shorter.
Okay. All right. Thank you, Mr. McMillan. I'll let you get on with it.
And I just want to know, well, let me ask a follow-up question. I just want to understand this one point that, Ms. Stremmel, I think part of what I understand the interveners' arguments are focused on is they seem to be identifying that there's, within the actual rate case context, you have cost containment mechanisms that will drive your company to make efficient choices. And if I understand their position correctly, just reading the materials that they supplied, they have concern that moving all of these things to the RPS rider is in some way going to cause that optimization pressure for cost containment to deteriorate. And I wonder, just as a pure matter of fact, what is it that the commission should understand as the company's response to that concern?
The commission should understand that the RPS requirements and the regulatory mechanism for RPS compliance, the RPS rider, were established in a time frame when cost of service rate making was fully known. The legislature intended for RPS costs to be recovered through a rider mechanism that has been established by the commission and consistent with SPS's proposals here can be reestablished or continued for purposes to recover self-billed generation. So SPS is not proposing a new rider. We're proposing to use a rider that the commission already has established. So I think it's very informative that the legislature understood that as RPS compliance requirements increase, the costs of that compliance needs to be demonstrated to customers through the rider alongside cost of service rate making, which occurs through base rate cases.
Okay, thank you.
All right. Mr. McMillan, you got anything left?
Yeah, I do a bit. So, Ms. Trammell, let me reacquaint you with the hypothetical. We have SPS has a capacity shortfall. They get a CCN to build a 1 gigawatt wind farm to resolve that capacity shortfall. And we're talking about how that interacts with the RPS. Are we back on the same page?
Are we back to number 3?
Yeah, we're about to start number 3.
Great, I'm there.
Number 3 and last, thankfully for everyone. So in scenario number 3, let's say that SPS projects that when that wind farm, the 1 gigawatt wind farm, goes into service, it will fall short of without the wind farm, would otherwise fall short of its RPS requirements by 1 REC. Are you with me on that hypothetical? Yes. Okay, in a single REC, that represents 1 megawatt hour of renewable production, correct?
Okay.
Is that correct? That was a fact question.
Oh, sorry, my apologies. Again, a very probably unlikely scenario that for the retirement period and any potential banked period that we'd only have 1 unit needed for compliance, but I'm following your hypothetical.
Okay, and just so we're clear, a REC represents 1 megawatt hour of renewable production, correct?
Yes.
Okay, so in that hypothetical where SPS needs 1 REC, do you believe SPS would be able to flow the entire cost of a hypothetical self-built 1 gigawatt wind farm through the RPS REC?
Yes, because that 1 megawatt or 1 REC is really no different from the cost of 1 REC needed from a PPA facility. The full PPA price, it's not prorated by the contract. The contract would be executed, and same thing here from a revenue requirement perspective. The self-build project would need to be constructed as approved by the commission. Again, assuming in your hypothetical the 1 gigawatt project, the 1 gigawatt wind project was approved by the commission.
Okay. Well, thank you for that. And we can move on from the hypothetical. I want to talk about one more thing. So to be clear, if the commission authorized recovery of these self-build solar facility costs through the RPS rider, that would benefit SPS, right?
Yes, SPS would be one beneficiary.
Okay, and one of the reasons that would benefit SPS is that flowing the cost of the self-build solar projects through the RPS rider would get the self-build solar facilities into rates earlier than if SPS had to wait for the next rate case, right?
My testimony called that reduction in regulatory lag. Yes.
Okay, and if we put these facilities into the RPS rather than base rates, that means SPS would start earning a return on those facilities earlier, correct?
Yes.
And as you mentioned, that decreases regulatory lag. It's the general term for that, right?
Beginning recovery, yes, that it's not really specific to the earned return component, but more the commencement of recovery, more of a timing consideration, yes.
And accelerating that timing decreases the risk for SPS, right?
I don't believe so.
So is it your testimony that SPS builds a facility and it goes into service the next day after energization, that there's not less risk there than if it goes into rates a year later?
SPS still has risk of the investment, risk of prudence review, risk of ongoing recovery of ongoing expenses. All that's really changed is the recovery mechanism.
Well, and the recovery timing, like we just established, right?
Yes, but regulatory lag can be also addressed through other mechanisms, like the timing of effective data rates in rate cases. We don't usually see that to be a material change in risk.
Can I ask a clarification question to that very question Mr. McMillan is asking? Does the fact that the rider is adjusts depending on over or under collection have any impact on your answer to Mr. McMillan that you just supplied?
It can. To use a term I think most of us in the utility industry are familiar with, base rate recovery can be lumpy in the sense of, the preciseness of recovery. Base rates are not trued up or down, whereas the rider recovery would have the revenue requirement trued up each year, as well as truing up the rider for sales. And that can impact the company's ultimate recovery position between rider and base rates.
Thank you.
Ms. Trammell, if the self-built solar facilities if their costs are flowed through the RPS rider, would that in theory mean that SPS could start earning a return on those assets before the commission had an opportunity to conduct a full prudence review?
Potentially, yes. So with the way the RPS rider is structured, the rate usually begins January 1st of each year.
I believe that's all I have. Thank you for your time, Ms. Trammell.
Thank you.
Here, Lieutenant Barrett, would it be mind if we took our morning break now? I would greatly appreciate that if we could.
Yes, that'll be fine. 10-minute break?
Sure.
All right, so we will take a 10-minute break. We'll reconvene at let's just plan to reconvene at 10 minutes past 10. And please remember the YouTube stream is still active during the break. All right. The time is now 10 minutes past 10. We are back on the record. Next up in the order of cross-examination, Ms. Gonzalez, are we ready to go?
Yes, give me 1 second here.
Or take your time.
Okay. All right, raise your right hand.
Oh, she's already been sworn in.
Oh,
I
sorry.
just wanted to make sure that you were back after the
Thought we
break.
were, oh, you're right. Hang on. I'm in the middle of things here. Okay,
That's fine.
I'm all together now. Sorry about that, folks. Go ahead.
No problem. Thank you. All right. Next up in the order of cross-examination is New Mexico Department of Justice. And Mr. Elliott, do you have any questions for Ms. Trammell?
I do. Thank you, Madam Hearing Examiner. Good morning, Ms. Trammell.
Good morning.
My first question is on page 11 of your direct, you discuss the minimum renewable energy requirements, the RPS requirements. And do you have that up?
I do.
Okay. And you're familiar with Ms. Reno's testimony, correct?
Specifically to the requirements?
With respect to the tax credits.
Generally, yes.
Okay. So my question is, can New Mexico achieve any of its RPS objectives if the federal government repeals the production tax credits and the investment tax credits?
But that's pretty speculative, so we'll go through some more hypotheticals today. The RPS requirement is not a function of federal tax incentives. It's a technology requirement. So in order to comply, SPS would procure additional renewable resources.
Would those renewable resources be built?
If approved by the commission. Yes.
Would they be economic?
They may be selected in resource planning processes differently from an economic standpoint, as we're, again, optimizing that portfolio of most reliable, most economic resources. But again, if needed for RPS compliance, they could be selected also outside of the multi-jurisdictional baseline specifically for New Mexico requirements.
So they could be selected, but not on, they could be selected for reliability, if not RPS, if it was outside of in a different planning paradigm, other than just an RPS standard.
Not sure I understand that question.
So I'm trying to understand if the rate credits and the production, if the production tax credits and the investment tax credits go away, I'm trying to understand how that would impact the availability of projects or PPAs in general for utilities to acquire, or if they would even be bid on in terms of the economics of them. If there aren't any projects developed in New Mexico, right, then I'm just trying to understand if they would be available for RPS purposes.
As I sit here today, I can't project what projects would be available for procurement in the future under different federal tax law parameters.
So let me just ask this. Do you think that if those production tax credits and investment tax credits go away, that the projects would be more economic or less economic?
All else equal? In other
Yes.
words, no other changes in underlying technology price that could affect the economics of renewable projects, yes.
As far as making them less economic?
Again, the investment doesn't change, but the value of the tax credit is flowed through to customers. And we incorporate that flow through value as part of the overall project cost usually as an industry, not just SPS.
So if it didn't flow through to customers because there is no credit, then the electricity would be more expensive. It
The
wouldn't be offset.
The total
price.
project costs could be more expensive, again, all else equal.
Okay. Has there been any change to the anticipated construction start dates and in-service dates for, is it plant X or plant 10? I don't know how we refer to it.
X.
Okay. Plant X and the Cunningham Solar 1 and 2 projects.
No, sir, no change in service date.
Okay. Based on the big one big beautiful bill, you're familiar with what I'm speaking about?
Very generally, yes.
Okay. Do you anticipate SPS would receive any production tax credits for the Plant 10 solar project, the Cunningham 1 and 2 solar projects?
The federal legislation is, of course, not finalized, or any changes have not been finalized or implemented. But I believe there are provisions for whether or not projects have begun construction. And so to the extent that is a provision in existing legislation or any changed legislation, these projects have started construction and therefore would likely qualify for PTCs and the ITC.
Okay. Have you guys been internally discussing how it might impact projects that are in the pipeline?
Xcel Energy is monitoring the legislative developments.
Are the Plant 10 solar, well, let me ask this. Are those projects viable without the production tax credits?
Yes, we believe so, but that modeling has not been specifically performed by SPS.
I see.
Wait, can I clarify? Ms. Tremble, you're saying that these projects are under construction already, but their Xcel or SPS does not know if they are viable?
His question was, would they be viable if they didn't qualify for tax credits? We believe these projects do qualify for the tax credits, so we haven't analyzed a future where they're not.
Okay, thanks.
Xcel hasn't. Have you asked anybody external to Xcel?
No, not me personally.
Are you aware of somebody having asked it?
No, I'm not.
Okay. What would the financial impact on ratepayers be if the Plant X project, Solar 1, Cunningham 2 did not receive the production tax credits? Would ratepayers see an increased financial burden or a reduction in their financial burden?
I don't have that information.
Okay. Let's move to page 35 of your direct, please.
Okay.
And on lines 14 through 6, excuse me, am I in your rebuttal already? Nope. This is where you're discussing, okay. This is where you're discussing I'm just looking for, I think it starts on, okay.
And Mr.
We're discussing
Elliott,
witness lies. Oh, I'm sorry.
Just to be clear, are you referencing PDF page 35 or the printed at the bottom of the page 35?
I believe I'm referencing, that might be my cause of confusion. Well, let me see if I start my sentence here. We're discussing Mr. Lai's testimony, I believe, and you state recovery through the RPS rider also aligns with the timing. Is that on page 35?
Yes, it is page 35
It is.
of Ms. Trammell's testimony. I'm looking
Thank
at it
you.
now.
Thank you. So you state that the recovery through the RPS cost rider also aligns with the timing of recovery with the receipt of the federal tax credits generated by the SPS solar projects and enables earlier receipt of value of the credits by customers. My question is this: isn't it true that the production tax credits will not begin to flow to customers until after recovery begins? And that's at some future period of time.
That is SPS's proposal, that the flow through of the value of the tax credits for the solar projects, just the PTC, would commence upon the commencement of cost recovery. So what this sentence is referring to, if I may, is if the cost recovery occurs through the RPS rider, and the RPS rider for plan year 2026 begins on January 1, 2026, and the 2026 solar projects go into service in 2026 and begin generating production tax credits, there would be no company retention of the value of PTCs.
Do you agree the RPS rider will be applied to customer bills before they receive any offsetting value?
No.
Or could be?
No, I do not.
Okay. Let's move forward to page 30. Well, that can't be right. You discuss using a demand-based allocator, the AED4CP, for new solar projects. I apologize. My pages are a little bit off. Might be in your rebuttal. Well, let me just go forward and ask you this. Have you done any sort of bill analysis that compares customer outcomes under the 4CP versus the traditional kilowatt hour based allocation and your mixed allocator proposal?
I don't recall.
Okay. If we can just, I've been flipping back and forth between open PDFs of your rebuttal and direct, so I apologize.
No worries.
I was looking at the exhibit that did not have a page 37. So flipping to your rebuttal. On page 6, lines 13 through 17, you refer to the REA section 16.4G3 as expressly authorizing utilities to recover the cost of self-build projects through the rider. But to your knowledge, is there any specific language that explicitly authorizes full capital cost recovery for a utility-owned generation by a rider?
Yes, make sure I understand your question. It's my understanding that section of the REA allows for recovery through the rider or other rate-making processes for a variety of ownership structures. I believe it specifically mentions PPAs, even build transfers, and self-build projects or company-owned projects.
But is it for cost recovery?
I'm sorry, what was that?
Was that hearing examiner Ryan?
Yeah, I tried to interject. I was going to ask a question, Mr. Elliott, but if you have a follow-up you want to ask, I just want to ask one. I'll defer to you.
Well, I was going to ask, is it for full capital cost recovery of the entire project?
Yes.
Okay. And which projects are you thinking of?
SPS has proposed to recover the 2026 solar projects through the 2026 RPS rider.
So we're referring to your pending, the current application that we're discussing.
Yes,
Okay. But there's no prior order in which that's occurred.
not for SPS. No, there have been for other utilities. I believe PNM has had 2 RPS cases where they've recovered a revenue requirement on a company-owned facility through their RPS rider.
And do you know how much they were seeking to recover?
I do not.
Did you look or at any time during your preparation for this case?
I just don't recall the value.
Do you recall if it's more or less than what you've proposed here?
It may have been less. I think there were smaller projects.
Okay. So if we move to page 17 of your rebuttal, you reference PN, yeah, this is where you're referencing. I'm going to skip this question. Let's go to 14. I'm sorry.
Okay.
Lines 1 through 7, you state that the 2026 solar projects are required for 2027 RPS compliance. Did you or any SPS witness present a quantitative scenario analysis that showing what compliance would look like without these recs?
I just want to make sure I'm looking at the right sentence. You
Sure.
said page 14, which line?
1 through 7.
The whole end of
Yeah,
that paragraph?
right.
Okay. Can you restate your question?
Sure. Did you or any SPS witness present a quantitative scenario analysis that shows what compliance would look like without the recs?
Mr. Gable can discuss the modeling of our compliance position for the plan year.
Okay. And just out of curiosity, because it came up during your prior discussion with Mr. McMillan, how much of the projects that are being proposed are required for New Mexico RPS compliance versus system?
I don't understand the question.
How much of the projects that are at issue here, Cunningham, Plant X, Cunningham 2, how much of those projects production will go towards meeting New Mexico RPS requirements?
In plan year 26?
Sure, yeah, and 27.
Okay, we'll take it one at a time. I believe the SPS self-build solar projects contribute 4%, around 4% of the plan year compliance need. But again, generation from these resources will need to be banked for future years compliance.
So it's, forgive my ignorance, but if it's 4%, that's necessary, how much of the cost is flowing through the rider?
Well, it's 100% when you're banking, right? So 100% of generation will be utilized for RPS compliance, but we're only retiring RECs in the plan year at 4% based on, again, the modeling projections for calendar year 2026. But 100% of the resources RECs need to be retired for RPS compliance eventually. So in 2026, 100% of the generation will be either retired or banked.
And so the cost of the project itself can't be recovered, or is it SPS's position it can't be recovered in base rates because it's a RPS project or a project that would count towards achieving the RPS standard?
Yes, it's SPS's position that the legislature intended for RPS compliance to be illustrated in the RPS rider, so that the RPS rider's intention is to show customers the cost of RPS compliance. These resources are necessary for SPS's RPS compliance and therefore should be in the RPS rider along with other RPS costs.
So if only 4% is going to achieve the New Mexico RPS, does flowing through the entire cost of it through the rider suggest that the cost is actually greater than what the 4% of the project is actually contributing to the New Mexico standard?
I object to the form of the question. I think it's misstating Ms. Trammell's testimony.
I actually didn't see this addressed in the testimony, so it was just a question.
Do you want to restate your question? Try again.
Sure. If 4% of the production of the credits is going towards New Mexico retirement, renewable portfolio standard, is that correct?
No, I disagree. I think 100% of the generation is going towards compliance. You said utilized. To me, you can utilize the RECs through retiring or banking. We'll be utilizing 100% of the RECs from the solar facilities in 2026 and beyond.
For meeting New Mexico's RPS?
Yes.
Okay. All right.
Wait, sorry, I need clarification on that because now I'm kind of confused about the nature of the testimony. So, Ms. Trammell, if I understood you correctly, when Mr. Elliott initially asked you, you said for this, which plan year will the resources provide 4% of the REC production?
I said that the 4%, or around 4%, I believe, was the contribution of REC retirements from the 2026 solar projects for plan year 2026 compliance. However, renewable generation in 2026 can be banked for REC retirement in future years. 100% of the output of the 2026 solar projects will be utilized for either retirement or banking.
I understand.
So 4% retired, 96% banked. Is that what we're saying? Okay. Okay. Mr. Elliott or hearing examiner Ryan?
No, I just wanted clarification, Mr. Elliott. It looks like you're thinking about this too, so take your time.
Thank you. And I guess I should ask, so when a credit is produced, can it be banked or retired those are the choices, right? As soon as it's produced?
And just to clarify, you're talking a renewable energy certificate or a production tax credit? You said credit.
Well, a renewable energy certificate, I guess, is the question.
Yes, my understanding under New Mexico rule is that the REC can be retired or banked. So retired in the current year or banked for retirement in a future year.
And that period of time is, what's that future period? How long is it?
It's my understanding it's 4 years.
Okay. Thank you for that. So moving on to page 31 of your rebuttal testimony.
Okay.
Lines 1 through 8. You defend SPS's use of the full weighted average cost of capital, the 7.17%, for recovery through the rider. Would you agree the true-up mechanism substantially reduces the risk for SPS compared to recovery via base rates?
No.
Why is that?
As I discussed earlier with Mr. McMillan, SPS still carries investment risk on the facility, regardless of the regulatory mechanism. And with the rider true-up provision, there's a true up of actual costs and sales. So for example, in base rates, if hypothetically sales exceeded the sales modeled in a test year, that would provide for additional revenue for the company as opposed to the test year revenue requirement. Conversely, if sales in a future test year context were under the future test year level, then that would reduce in less revenue to the company, right? That's kind of the lumpiness we say of base rates. Here in the rider, everything's trued up. So we have a true up of actual costs and a true up of actual revenues. It's a very transparent and precise recovery mechanism for RPS compliance costs, and particularly the self-billed revenue requirement. That level of base rate true up does not occur. That level of true up does not occur in base rates. So there is essentially no risk of over earning or under earning there in the rider, but that does not change materially, I think you said significantly, the risk profile or the risk assessment of SPS, which is what investors are looking at when they're looking at the company for either debt or equity investment.
So the time period that we're talking about where investors might change their opinions about SPS's risk exposure would be between, well, this was originally proposed in 252, right? The original treatment that you're seeking here.
Are you referring to the RPS right of recovery?
Mm-hmm.
Yes.
Okay. And PNM and SPS's next rate case, is that right? Because it could also be addressed in SPS's next rate case. That's the alternative proposal, right? As opposed to dealing with it now in this proceeding, deal with it in SPS's next rate case.
When you say deal with it, are you referring to risk or recovery?
Deal with the tax credit treatment here that you're seeking. It's been previously proposed in 252. The commission deferred it, correct?
Yes. The tax credit treatment is a matter in SPS's fuel continuation proceeding, not this RPS proceeding.
But how the commission handles it or how it's addressed could also be handled in the next rate case, correct?
The tax credit flow through to customers?
Mm-hmm.
It could,
Okay.
if that's what the commission were to decide in the fuel continuation case.
So my question is, would that have a negative impact on SPS's credit metrics? If it was deferred until that time?
The flow through of, in this context, production tax credits is a benefit to customers. It's the value of it's us returning the value of, not returning, it's passing through the value of the tax credits through the fuel factors.
Okay. So the pass-through, the true-up mechanism, it does reduce, you're saying that the true-up mechanism benefits customers, but it also reduces the regulatory risk for SPS. Is that fair?
Objection. It misstates Ms. Tremmel's testimony that she's just given.
Okay.
Mr. John, let me ask a question. I think you're trying to ask. It seems, Ms. Trammell, and let's think about it this way. If you were to, in a rate case, propose a future test year in which the costs for these facilities was projected, and you develop the rates to capture those costs, you remain in that moment capable of over-earning because you as a company could find efficiencies that beats the expectation. It would seem to me that on some level, if it's through the rider with automatic adjustment clause, then in many regards, like taking away the potentiality for you to over earn because of your efficient conduct is minimized. And I'm not sure if I'm articulating the question exactly, but that's at least what's going through my brain right now in terms of just listening to your dialogue here. So can you address that to the extent you can, please?
Sure. I think it's helpful to recognize that risk analysis is a broader evaluation than just the recovery of one set of costs or utilization of one mechanism, right? We're looking at the business risk of the entity, SPS or Xcel Energy, and the regulatory environment risk, right? There's a number of factors that play into either a debt rating agency's assessment of risk for a utility in a jurisdiction, or equity investors' assessment of risk when comparing investment options of presumably comparable risk, right? So the RPS rider exists today. The REA provides for recovery of self-billed revenue requirements. It is true, SPS has not recovered any self-billed renewables through the RPS rider to date, but from an investor perspective, that right exists. That mechanism is in place, that framework is in place. If the revenue requirement for this SPS solar projects are recovered through the RPS rider, that meets expectations of investors, because that is the expectation under the framework that's been established by the New Mexico legislature of the jurisdiction. If the projects are not recovered through the rider, it's SPS's position that that would significantly negatively impact investor perception of the jurisdiction, because SPS would be essentially told it is unable to use a regulatory mechanism as statutorily authorized.
I guess the question I would ask in response, or just trying to get, do you think, and I'm not asking you to offer a legal opinion, it's more from the commission's actions, like what it authorizes and does not authorize, even within existing statutory structures, that it's there to produce incentives to make sure that you're providing efficient service as cost effectively as possible. I mean, in other words, did the company in this case take the position that it should be maximizing efficiency, and that'd be appropriate for the commission to structure things so that that's sort of placed on you all to do that?
I'm not sure I completely understand the question, but efficiency is not an unreasonable expectation from a utility, from the commission. But I think it's also, again, a mechanism that exists in the jurisdiction that was created alongside base rate cases and cost service rate making.
Yeah, and I guess the question I'm trying to ask you is to stay away from the law of it all. The basic question would be, does the administrative entity, from a purely legal perspective, retain the discretion to decide whether or not you can operate under those functions? I mean, that's a question of power and law, but there seems to me to be a question of, like, from the company's perspective, what set of facts will most likely lead to you engaging in the most efficient behavior? And I guess my question I'm asking you is there a world in which the commission says, no, we don't think, even though that rider exists to provide you something, that doing that is the most optimal?
I'll leave the legal conclusions to the attorneys, but I think the commission has the authority to evaluate rate making requests and can make its determinations based on, the evidence, and issue its decisions based on the evidence it considers in that evaluation.
Yes. And I have a quick follow-up or clarifying question. Is it based on the conversation you were having with Mr. Elliott? Is it a fair statement to say that it is beneficial to SPS as far as its creditors and credit ratings go to try to get as many costs flowed through riders as opposed to base rates as possible.
Generally, a reduction in regulatory lag is positively viewed from an investor perception perspective. Now, regulatory lag can be addressed, as I mentioned before, in base rates or in rider mechanisms. New Mexico does have a future test year construct. SPS's position with respect to lining up a lot of these matters, particularly for these self-build solar projects, which do have tax advantages to them, is the rider recovery is in the public interest and benefits customers, aside from the true-up provisions that I've already talked about, by aligning the time period of when PTCs can be, the value of PTCs can be returned to customers through fuel. So if we are recovering the revenue requirement through the RPS rider, as opposed to base rates, the retention of PTCs by SPS, that time period is further limited. And I say further by mean of further than even contemplated in the fuel continuation settlement. And that is an additional benefit to customers of rider recovery through the RPS. This is why SPS presented all of these matters initially in the CCN, reviewing these projects, even though they are the venue for how these components flow through to customers may differ. They are all related to the same project, right? So especially for a tax advantage resource like solar, it's important to consider the dynamics of both when looking at the overall picture of the project. So again, we think that the rider recovery not only is consistent with New Mexico's intention, as I've stated, to have RPS costs reflected in the rider, but also in the public interest by providing that true-up mechanism, again, for costs and sales, and then lining up the period of PTC flow through to customers with the commencement of cost recovery.
And I understand that, and I think you've expressed that well. My question was somewhat broader, which is, if I'm hearing your testimony, reducing regulatory lag is good for SPS's credit metrics. Riders reduce regulatory lag. Therefore, riders are good for SPS's credit metrics. Is that a fair statement? Just generally, not considering tax credits or specific to this case.
They can be, and it depends on the mechanisms of the rider. I'll say in the RPS context, where it's a forecasted revenue requirement, that can be more beneficial, say, in comparison to a historical test year in a rider. So, Your Honor, I appreciate your question. I don't mean to be splitting the hairs, but how that rider is constructed also matters in its ability to reduce regulatory lag. And I would just acknowledge that RPS rider is a forecasted revenue requirement, which in the context of your question does work to reduce regulatory lag compared to different rider constructions.
So can I ask a question? I want to, Ms. Trammell, I believe this comes from Charles Phillips's text. I mean, there is at least a thought that indicates that regulatory lag, from the company's perspective, it's something to avoid, but from the regulator's perspective, there's at least an argument that goes, regulatory lag ensures efficiency from the regulated entity because it requires you guys to make a projection and act in such a way around the projection. And I guess I'm wondering, do you acknowledge that there is a positive aspect in the regulatory environment associated with regulatory lag?
In the context of base rates, yes, but the REA also acknowledges that RPS cost recovery should be timely.
Examiner Ryan or Mr. Elliott? Okay, Mr. Elliott.
Ms. Trammell, do you know how many RECs you anticipate retiring in 27?
Not off the top of my head, but we can look at attachments, or that can be probably better addressed by Mr. Gable.
Okay. I have no further questions. Thank you for enduring my questions.
Thank you.
Thank you, Mr. Elliott. Ms. Trammell, do you need a break, or are you good to go for the next? I believe CCAE is next.
I think I'm good. Thank you.
Okay. So next in the order of cross-examination is Ms. Lynch for CCAE. Ms. Lynch, do you have any questions for Mr. Abel?
Your Honor, I do not have any questions. Thank you so much.
Okay, great. So then in the order after CCAE is New Mexico Large Customer Group.
Thank you. We do have some questions.
Go ahead.
I think it's still morning, Ms. Trammell. Good morning.
Good morning, Mr. Stoffel.
Thank you. Just high level, right? You agree that there are no uneconomic costs as historically used in the context of the RPS rider for the SPS solar projects, right?
Correct. For, you said solar projects, I'll say 6 and 7, 26 and 27, yes.
Okay. So those do not reflect costs that SPS would not have incurred but for New Mexico's RPS requirement, right?
Can you say that question again? I just want to make sure I'm following.
The 2026 and 2027 SPS solar projects do not reflect costs that SPS would not have incurred but for the RPS requirement in New Mexico, right?
Yes, I think that's right.
They were part of the least cost, least risk portfolio from the last IRP and RFP cycle, right?
Can you explain what you mean by least risk?
Well, I was using that as I understood the company to use it. So they were part of the company's preferred portfolio coming out of the last IRP and RFP process. Is that right?
We called it recommended, but yes.
Okay. And so they're similar to Hale and Sagamore in that there'll be SPS-owned renewable resources that were procured for something other than RPS compliance, right?
Their purpose is beyond just RPS compliance, yes.
So Hale and Sagamore were initially proposed as economic resources, and they also helped the company comply with the RPS, right?
Yes.
And the 2026 and 2027 solar projects were proposed to meet the company's capacity and energy needs. And then they also helped to meet the RPS requirement in New Mexico, right?
That's correct.
And you agree that Hale and Sagamore, as wind generation facilities, displaced SPS's future need for new resources to comply with the RPS, right?
Yes.
And one of the distinctions you've raised today regarding whether a renewable resource should be recovered through the RPS rider involves whether the facility produces RECs, and if those RECs are either banked or retired to comply with the RPS, right?
Yes, we've discussed that.
Do you agree that New Mexico law requires utilities to retire RECs from rate-based resources?
Yes, I believe it does.
Oh,
I believe that language is a shall.
I was going to object to calling for a legal conclusion, but Ms. Trammell has answered, so.
I thought it would be within the scope of her experience there. So
I would agree.
Also testified that recovery of the SPS solar projects through the RPS rider would provide an incentive for.
I'm sorry, can you repeat your question?
Yes. You've also testified that recovery of the SPS solar projects through the RPS rider would provide an incentive for SPS to invest in renewable generation, right?
Yes, I believe that was discussed in my direct testimony.
And you would agree that SPS and its parent company, Xcel Energy, have an incentive to invest in renewables due to their own corporate goals, right?
Can you explain what you mean?
Are you familiar with Xcel's corporate goals regarding emissions?
Yes, but for purpose of RPS compliance, our milestones are the requirements outlined in the REA.
And for the record, can you tell us what the company's corporate goals are for emissions?
Enterprise-wide, the company has a goal of 80% carbon emission reductions from a 2005 baseline by 2030. Again, that's enterprise-wide across all jurisdictions. So different operating companies can contribute differently to the enterprise goal.
And that enterprise goal doesn't stop in 2030, correct?
It does.
You do not have a zero emissions by 2050 corporate goal?
That's an aspiration.
Aspirations are different than goals?
Yes, Xcel Energy, when it announced the corporate goal and the aspiration, acknowledged that clean energy technology would have to advance in order to progress past an 80% carbon emission reduction future.
And SPS is obligated to procure new generation resources to meet customer needs, right?
We have an obligation to serve. That procurement can come from multiple resources, as we've discussed, PPA or self-builds.
And those resources might be renewable, correct?
They could.
And SPS is also obligated to comply with New Mexico's renewable portfolio standard, right?
Yes.
Now, you had some discussion earlier with hearing examiner Ryan around kind of your vision of RPS rider recovery and how future renewable energy production facilities would be recovered through the RPS rider. Do you recall that discussion?
I wouldn't call that my vision, but I tried to navigate a multifaceted hypothetical. Yes.
You would not be upset with a world where all of the company's future renewable energy generation was recovered through the RPS rider, correct?
It's not about what I feel. We believe that's the intention of New Mexico frameworks.
So if that were the case, you agree that an increasing amount of costs would likely be recovered through the RPS rider?
Potentially, because the requirements for compliance are increasing over time.
If we look at your rebuttal testimony on page 2, that's page 5 of the PDF.
Okay.
So there, starting on line 14, you testify, my rebuttal testimony responds to parties' arguments against SPS's proposed use of the rider to recover owned renewable projects, a right that they do not dispute exists under New Mexico law. Do you see that?
I do.
You agree with me that New Mexico law does not provide a right to recovery through the rider, correct?
I think I would disagree.
The New Mexico statute provides a right to recovery through the rate-making process, correct?
Of which the RPS rider is a part of.
But the statute does not mandate recovery through the RPS rider, correct?
Doesn't preclude it. I mean, it refers to the rate-making process, and the RPS rider is a component of this jurisdiction's rate-making process.
And just to make sure my record's clear, when you say does not preclude, that also means it does not require, correct?
Yes, similarly as it doesn't require base rates.
Both are forms of the rate-making process, right?
Yes.
So under base rate recovery, for an investment in rate base, like the SPS solar projects, the revenue requirement would include a return on that investment at the company's weighted average cost of capital, or WACC, right?
Yes.
And you also propose a WACC return for recovery through the RPS rider?
That's correct.
Would you agree that in general, equity investors are compensated based on a risk of loss?
I would say equity investors are compensated for risk of comparable investments.
And when they're comparing risk of comparable investments, one of the risks is that they don't receive a return of their investment, right?
Or a full return.
Or a full return. And so for example, a 30-year treasury is considered relatively low risk because there's relatively minimal risk of them not being repaid, right?
I would agree.
And in contrast, even in a relatively safe investment like a utility, an equity investor could face the risk of not being repaid, for example, through a bankruptcy related to a wildfire.
Can you restate your question?
That an equity investor, even in a relatively safe investment like a utility stock, faces a higher risk of not receiving repayment of their investment as compared to a lower risk investment like a treasury, right?
Okay,
Do you agree with that?
I do.
So earlier you've had some conversations around base rate recovery and you described that as lumpy, right?
It can be, yes.
And you had the discussion with hearing examiner Ryan not too long ago about how with base rate recovery, you could have the opportunity to actually lower your costs and earn a return higher than what was authorized, right?
Or have different sales.
Or
I believe that was the discussion I had with him, yes.
right. And so that revenue requirement is fixed, and then your actual recovery can vary high or low compared to what was expected based on the time rates were set. Is that right?
Yes.
And so I think you'd agree with me based on your experience in regulation here that it's common to look at the revenue requirement for base rates as a utility's opportunity to recover their costs and earn a return, right?
I don't think that it's an opportunity to recover costs. It's an opportunity to earn a fair return, but prudently incurred costs are to be recovered under the regulatory compact.
And in general, though, the prudently incurred costs, the return on the investment, all of that is combined together in the revenue requirement used to set base rates, right?
Yes.
And so you have the opportunity to make sales at those rates, and then whether or not that achieves a specific return just depends on your actual costs and sales like we're talking about, right?
I wouldn't put the opportunity on making sales. But yes, there's an opportunity to earn an authorized return in cost service rate making.
Sorry, I didn't mean to interrupt for Ms. Trammell. Ms. Stoffel, I wanted to, can I ask Ms. Trammell a question? And I think it's sort of, I think I know what, I think I understand where you're going, and I want to just, Ms. Trammell, I'm sorry, I just have to interrupt. Sorry.
No, I apologize for talking over you, Your Honor.
No, I was more apologizing to Mr. Stoffel, but I guess this is the question I'm thinking in the back of my mind. I remember attending a NARUC presentation about the value of securitized, I forget what they call that, when you abandon a plant, like in the P&M context, they abandoned the San Juan and then they securitize. Yes, and the question was, what is the risk profile of that security? And the individual who was presenting this said that, effectively having ratepayers be obligated to pay the securitized costs of the abandoned plant is almost better than a treasury bond, because that's never going to go away. I mean, the ratepayers just have to pay it. Where I guess as the federal government get default or on its debt, or we see stuff happening, kind of crazy things in the federal government right now. So in many ways, I'm sort of wondering, is the RPS the same? I mean, if your position is that the legislature provided the utility the capacity to cover effectively all renewable costs through a rider mechanism that's self-adjusting, if we were to take that to a sort of the furthest position out there, in fact, it seems like a very strong way to preserve the capacity to get the returns, almost in the same way that a securitized abandoned asset, the ratepayers are obligated to pay for it. Is that a fault? Am I just totally off in my thinking there?
Also a lot in that discussion. I'll do my best, Your Honor, to respond. So you're referring to securitization and specifically what is commonly referred to as a non-bypassable charge when there is statutory authorization for that very specific financing vehicle, which is securitization. Here we do not have any kind of statute enabling securitization for this purpose. I know that's not quite what you asked, but just level setting on a non-bypassable charge is non-bypassable because it's established in statute, or I guess it could be different jurisdictions, but that's generally the foundation. That is a very, very specific financing vehicle that is not at play in the financing of RPS compliance costs, specifically for self-billed renewables. an entity like SPS is financing this investment through its debt and equity, not a securitized bond. So I think the scenario you laid out is very, very different, because the financing, the utility financing of the underlying investment is a mix of both debt and equity, not through a securitized bond issuance.
Okay, I understand the response. Thank you.
So, hearing examiner Ryan, may I continue?
Sure, please. Thank you.
So if the SPS solar projects were recovered in base rates, you would have an opportunity to earn a fair return on those investments, right?
It's really an opportunity to earn authorized. Yes.
But rider recovery with a true up for both costs and sales converts that opportunity into a guaranteed return on the investments being recovered through the rider, correct?
All else equal, correct. And by
so-
that, I mean the commission approves all of the costs through the rider and the true up.
And so in the company's view, the more generation resources that get recovered through the RPS rider, the more of a guarantee you would have to earn the authorized return on those investments, right?
Yes, the authorized return is a component of RPS compliance costs if approved by the commission.
And that component would be included in the true up you've proposed, right?
Yes.
Now, the actual costs of the 2026 and 2027 solar projects are not known as we sit here today, right?
No, sir.
And the company did not use updated forecasts or estimates for those costs, correct?
There are no updated estimates from the certificated cost estimate approved in the CCN.
And so as we sit here today, if RPS rider recovery is approved, we have no idea what the true up for that might look like, right?
That's correct.
Now, you've mentioned a few times the settlement agreement in the SPS fuel and purchase power cost adjustment clause renewal proceeding. Do you have that in mind?
Yes.
And recognizing that settlement's still pending before the commission, just a couple pieces on it. So there were some aspects of that settlement that provide a form of compensation to SPS prior to cost recovery for these resources beginning, right?
Can you explain what you mean by compensation?
So, for example, under the settlement in that proceeding, SPS is entitled to retain the production tax credits for a period of time prior to cost recovery beginning. Is that right?
Yes, I wouldn't call that compensation, but yes, there is a PTC retention period outlined.
That's value that the company can retain, right?
It's value that we're not advancing to customers before a tax credit position is recognized by the tax entity, SPS.
And under that settlement agreement, the company can also retain the margins from off-system sales for these new resources prior to cost recovery, correct?
That's correct.
Last couple questions here. So SPS controls when it files rate cases, right?
Generally, yes, absent the commission ordering a particular filing date.
And SPS also controls the structure of the test year used in its rate case filings, for example, a future test year, correct?
Again, unless otherwise ordered by the commission, that's correct.
Thank you. No further questions.
Thank you, Mr. Stoffel.
All right, thank you. Next up, in the order of cross-examination is LES.
Madam Hearing Examiner, all of my questions have been answered by prior counsel. Thank you very much, folks. And so I don't have any other cross. Thank you.
All right, thank you, Ms. Drake. So then we go to our last cross-examiner, which will be staff.
Thank you. Good morning, Ms. Trammell. My name is Renee Weiss. I am counsel for NMPRC staff. The attorneys for the interveners and the hearing examiners have addressed many of the questions that I had for you today, but I do have some clarifying questions.
Okay.
let's first turn to your direct testimony at page 15. And I'm looking specifically at lines 6 through 13. So I'll just give you a moment to get there.
Okay, I'm there.
Now, focusing specifically on line 11 to 13, you testified that in case number 23-252, staff in post-hearing briefing allegedly acknowledged that SPS could seek to recover the costs of the solar projects through the RPS cost rider, as long as the costs are consistent with a commission-approved REA plan. Did I correctly summarize that portion of your testimony?
Yes, and that's a cite from staff's post-hearing brief.
Okay. And are you familiar with staff's position in case number 23-252 as it relates to the proposal to recover the costs of the solar projects through the RPS rider?
It's my understanding that staff's recommendation was to the extent the generation from the solar facilities and the RECs are being used for RPS compliance, that should be presented in an REA plan, and eligibility for rider recovery is dependent on an approved REA plan, which was not an authorization that was going to happen in the CCN.
Isn't it true that in 23-252 staff ultimately recommended rejection of SPS's request to recover the revenue requirements of the solar projects through the RPS rider, and instead recommended that the costs of the solar projects be addressed in a base rate case?
I don't remember the base rate case recommendation. I do recall staff's position being the rider recovery should not be authorized in the CCN because the commission needed to see RPS compliance in the plan year demonstrated in an REA filing, or in other words, for the generation to be a part of an approved REA plan for SPS.
And if I understand your testimony correctly, you're testifying that you don't recall whether staff ultimately recommended that the costs of the solar projects be addressed in a base rate proceeding?
I don't remember that being a part of the recommendation, but I'm also not looking at staff's testimony at the moment.
That's fair. Thank you. Those are all the questions that I had for you.
Thank you.
Thank you. Hearing examiner Ryan, do you have any questions for Ms. Trammell?
I probably do. It might be some just purely clarifying questions. Ms. Tremley, just bear with me. I make my notes in your testimony. I'm just going to scan through that. Find those. Does the as SPS is contemplating these matters, does the fact that the statute say that you are to make consistent progress towards complying factor into any of what you've described today? And I'm not asking you to give me a legal answer. Do you understand the part of the statute that talks about how you consistent and I forget what the exact words are, progress? You have an obligation not only to meet them, but to show, I think the idea is sort of aspiration to exceed, if you will. That's kind of an interpretation. Does that factor into what you're proposing here today at all?
Specific to RPS cost recovery, no, I do not think it does.
Okay. at page 34, you describe of your direct testimony the IRP rule, the capacity projections that the planning and the IRPs are meant to achieve, and then you talk about the RPS rider can be utilized to smooth impacts. I guess I'm confused as to what is the relationship in your mind or from the company's perspective between the IRP and the propriety of collecting costs through the rider, and to the extent to which that's generated, the need to do so is generated by the IRP. Can you clarify for me what you're trying to communicate here at lines 12 through 17?
Sure. This discussion is meant to represent that resource acquisition decisions will be made in IRP processes. Under the Commission's revised IRP rule, which requires competitive solicitations, that's where the portfolios are being developed. So as units retire, as there's load growth and additional needs on the system, the IRP process will be where that generation selection originates. It's also my understanding that the REA requires that if RECs from a facility are to be retired for RPS compliance, that resource has to have been selected through a competitive solicitation process. So by nature of the Commission's rules, between 572 and the IRP rule, we are connecting these regulatory processes. This paragraph also illustrates that as the RPS compliance requirements increase over time, SPS will be adding new generation resources. So we'll either be adding them as generation retires, PPAs expire, as load grows, or to meet RPS compliance. So if we envision a future where there's material amounts of new generation added to the system, the IRP process is not as long in New Mexico as it is in other jurisdictions, but it's certainly longer than the annual RPS process. So in the IRP process, we'll be selecting portfolios for multi-year resource acquisition periods. Generally, SPS and other utilities don't file annual rate cases. So as we add additional generation to the system for these needs that I've discussed, that can make the generation addition or the drivers of the base rate revenue deficiencies larger in those periodic rate cases. So rider recovery on an annual basis as generation is added to the system can smooth the cost impact of those generation additions over time rather than collecting multiple resources in periodic rate cases for recovery. It can also add an intergenerational benefit there, but largely this portion of my testimony is discussing the timing of increasing generation additions and the smoothness of that rate impact through a rider versus base rate cost recovery. Again, with the assumption that a utility like SPS is not filing an annual rate case.
And the smoothing you're referring to, is that smoothing from the perspective of increases in the actual cost to the ratepayers themselves? Or is that, are you referring to a smoothing of a different kind of smoothing for purposes of the utility adding additional investments, or what is the smoothing you're referring to there?
Smoothing of customer impact. So it would be smaller, more gradual increases over time as opposed to periods where there's no increase and then rate cases where all the investment is brought into base rates.
Is the RPS rider, from the company's perspective, the goal that is attempting to be achieved there, transparency of cost to comply with Renewable Energy Act requirements?
That's our understanding and position, yes.
And again, that's the idea is to illuminate for customers, here is the cost to you of our compliance with the REA And at least ostensibly, that legislature having enacted this thing, it must think that the rider is the way to do that. I guess the question for the company, I suppose I'll ask you is, do you agree that the most effective way to communicate to customers the cost of complying with the IRA is through the rider itself?
Yes.
And that, do you agree that that'll continue to be the case even when 100% renewable energy is required?
Don't believe the 2045 requirement is 100% renewable energy.
Okay, but as we have an ever increasing proportion of the generation portfolio that exists in all the industrial utilities in the state, the position of the SPS is that still would be the rider is the appropriate mechanism to communicate to customers. This is the cost of doing this.
Yes.
The production tax credits, to the extent to which we're going to talk about those in this proceeding, those could also, you could project outwards and then build them into base rates if we went that route. Is that correct or no?
Do you mean the flow through of
Yes.
production tax credits to customers? Yes, that could be a credit embedded in base rates. That is not how the commission has historically authorized the flow through, and that's not how SPS has proposed it either in the CCN here or in the fuel continuation. And generally, most parties agree with the flow through the fuel factors because the PTCs are as generated, which varies by month.
Okay. How does authorizing recovery through the RPS, and I'm looking here at page 36 of your direct, lines 14 through 16, you say that incentivizes SPS to acquire new resources. Could you explain how that is true? From your perspective, anyway.
Sure. The RPS requirements do increase over time, and continuing to acquire incremental renewable resources for RPS compliance will be an increasing standard for the company over time, again, following these milestones. Rider recovery can incentivize SPS to potentially acquire new resources earlier than it otherwise may, since those RPS milestones are blocks. You know, it's, for example, 50% until it's 80%. And so we can make more progress towards future RPS compliance with the addition of additional renewable resources. More timely recovery can aid the company in financing the cost of those investments for self-build, or even more timely cost recovery of development projects is supportive of those investments. But in the context of this case, we're talking about self-build revenue requirements, so this is tied to the rider.
Well, I guess what I heard you say there, I mean, the statutory standard is set, the company must comply. There is a question, I know we've dealt with in some other IOU contexts, for instance, with El Paso Electric, you know, what happens if the utility falls behind, and what teeth is there really for the law to be enforced in some meaningful way? But what I heard you just say there isn't so much that there's a incentive to get you to comply with the REA because you just have to do that. What I heard you just say, and again, if you want to correct me, I'm misunderstood you, is it's more desirable to the company to move these costs through the rider for reasons that you've described in other discussions with everybody today and in other areas of your testimony. Am I misunderstanding?
I'll say compliance requirements or an obligation to comply doesn't mean compliance is easy. And in a multi-year resource planning process under New Mexico rules, generation is not, generation is not added just in time, right? We're not adding like in the year potentially that we need RECs to retire a bank for RPS compliance. So the rider recovery in a favorable framework, regulatory certainty, predictability of how these costs are going to be handled in the jurisdiction can take some questions off the table for utilities trying to manage a multi-year resource planning process while also ensuring that RPS compliance is met. We're not generally able to go through an IRP proceeding every year. Yet we have to be demonstrating RPS compliance every year, which is also trued up against sales. So it is in the public interest and it benefits the company to have this predictability for how the costs are going to be recovered, how the framework's going to work for self-build renewables in an environment where requirements are increasing and we're only soliciting resources every few years through a multi-year resource planning process. If it was as easy as just kind of submitting an order for a renewable project each year for what's needed in the next year's compliance position, that would be much more simple than the utility industry realities that we actually operate in, with a solicitation requirement in the New Mexico rules and a multi-year resource planning process that looks at potential generation additions multiple years in advance.
On page 37 there, at the bottom, lines 8 through 11, you talk about the current rider allocation being on a per kilowatt hour energy basis, and then transitioning to the AED 4CP. I'm sorry, Ms. Gonzalez, that's a lot of words. Allocation factor. The basic question was why the change? And I think I have the answer, and I just want to confirm that I understand correctly, which is, if you're going to, I mean, if you take the intervener's position here, they're saying this has traditionally been done through base rates. Now they want to push it through the rider. And so it sounds like in this, what you're describing here, and I'm asking you to correct me if I'm mistaken, the change in the allocation factor is trying to account for the fact that you're doing something that was traditionally done through base rates, where we would have different types of allocations, not on a per kilowatt hour energy basis. So can you correct me if I'm wrong?
First, I would just clarify this production capacity allocation factor proposal is for the SPS solar project. So the existing costs in the RPS rider would be unchanged.
Right.
But with that clarification, yes, if these projects were being recovered through base rates, presumably they would be allocated similar to other generation in SPS's rate base, which is a production demand allocation factor. The exception, again, being the outlier of Hale and Sagamore wind facilities, which have not been established in SPS's rate base under a particular cost allocation methodology due to the fact that rate cases have been resolved through black box settlements.
Just moving on, what is on page 45, you described the difference in costs for the projected DG, distributed generation. The actual costs were significantly higher than the projected. I was curious why that was.
This was an item applicable to our RPS report and an item discussed by, I believe, Ms. Lees in SPS's RPS filing last year. My testimony here is summarizing the errors that have been corrected and are incorporated into the true-up that we'll be filing in July.
Okay.
I'm sorry, I said true-up. I should say report. Report comes in July 1st under the variance order.
Okay, and I'm just moving on to the rebuttal testimony. Okay, I think that's pretty much everything I have for Ms. Trammell. A lot of the subjects I was gonna ask about were covered as folks were asking questions, so thank you, Ms. Trammell.
Thank you, Your Honor.
I have two brief clarifying questions for you, both of which are about your rebuttal testimony.
Okay.
You make a statement on page 7, that's printed page 7. Line 10, there's a question asked, and in your answer, you're comparing the SPS solar projects to Hale and Sagamore. You say Hale and Sagamore were not approved based on their RPS or capacity benefits. Unlike SPS solar projects, Hale and Sagamore were not approved based on RPS or capacity benefits. The inverse of that being that you're saying the SPS solar projects were approved based on RPS or capacity benefits. Is that fair?
Correct.
Are you referring to the commission's approval in the 252 case that we've been talking about, the CCN approval?
Yes, Your Honor.
In what way in that matter were the solar projects approved based on RPS benefits if that question was deferred?
The CCN largely addressed the capacity need of SPS's system at the time and the contribution of these solar resources to address that capacity need. That's why the testimony is or. The or is applicable to Hale and Sagamore, which it wasn't RPS or capacity. The solar CCN was addressing the capacity need. As I discussed before, we discussed the anticipation of the need for RECs from the solar facilities for RPS compliance, but again, that specific plan year information was not demonstrated in the CCN case.
Okay, so then we can just say for clarity's sake that the SPS solar projects have not received any kind of approval thus far from the commission based on our potential RPS benefits.
Correct.
Okay, and then we go to page 29, printed page 29 of your rebuttal.
Okay.
Starting on line 9, you're discussing the commission's grant of the variance, which allowed you to file in April as opposed to July. You state on line 12, the commission has expressed a preference to decide this matter in a timely manner. I think that's supposed to say timely manner. And
Yes.
specifically, I didn't notice it before either. And specifically before SPS's next rate case. Did the commission explicitly say that they have a preference to decide this matter in a timely manner? Or is, well, that's the end of my question.
Yes, in approving that petition, I think the commission is agreeing with SPS that the manner matters. The manner in which these costs will be recovered matters, and therefore deciding this in advance of the base rate case proceeding is a question that should be asked and answered in this RPS case.
But the commission in the CCN case, in the 252 case, the commission, when they deferred this question, said it could be addressed either in an RPS case or the next base rate case. Is that true?
Yes.
So are you saying those two are in conflict with each other? Initially, the commission said the question could be addressed here or in a base rate case, but it's the company's position that in granting the variance, they took the option of addressing it in the base rate case off the table?
No, I'm saying they didn't express a preference for that. If the commission wanted to see the decision made in the rate case as opposed to the RPS case, presumably they could have denied the petition. Now, that doesn't mean that necessarily they're expecting it to be decided in this case. I think what they're saying is it needs to be a question asked and answered in this proceeding. And they intend to make a decision as to whether it should be in this case or should be in the rate case in this case. It seems like a lot of process, but again, I do think the manner in how these costs are going to be recovered does matter and is in the public interest to resolve these items in this proceeding. And we hope that the commission does.
Okay, so it's SPS's position that it's in the public interest that this question be resolved in this proceeding, and it's an assumption that the commission agrees with SPS.
Well, my testimony is the commission did not express a preference for base rate recovery.
In the
variance,
in the granting of the variance, they didn't
Yes.
express, but in the CCN case, they did in fact give the option, either an RPS case or a base rate case.
Agreed.
Okay. That's all the questions that I had for you. Do any of the parties have any follow-up questions based on specifically on Commissioner Ryan or my questions?
Your Honor, I do have some questions.
Okay.
Okay. Hello, Ms. Trammell. It's
Hello.
good to see you again.
Likewise.
Thank you. I was wondering if you could elaborate for us upon Excel's emissions goals and whether those goals match up with New Mexico's Renewable Energy Act, or it sounds like they may exceed them.
I don't recall a discussion about Excel's goals with the hearing examiners.
I don't know if it was.
No, I think
I
Ms.
just know it
Trammell,
was.
Ms. Lynch, I think Ms. Trammell is correct. Neither Commissioner Ryan or I brought up Excel's emissions goals. I think that might have been Mr. Stoffel.
Okay.
So
Thank
that
you
is
for the
outside.
clarification. Then my next question is, are you familiar with the Renewable Energy Act provision at 62.16.4D, which states, and you may turn there with me if you'd like, that upon a motion or application by a public utility, the commission shall, or upon a motion or application by any other person, the commission may open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standards set forth in this section, results in reductions in carbon dioxide emissions earlier than required by subsection A of this section, or causes a reduction in the generation of electricity by coal-fired generating facilities, including coal-fired generating facilities outside of New Mexico. The incentives may include additional earnings and capital investment opportunities for resources used in furtherance of the outcomes described in this subsection.
I'm going to object to the question. I'm not sure how it relates to the hearing examiner's follow-up.
It relates to the costs and the cost recovery mechanisms used for renewable energy, renewable energy compliance, and the company's decision to potentially exceed the RPS.
Okay, so, but in this question, you're just asking Ms. Trammell if she's familiar with this part of the REA.
That just to establish, because we've been talking about cost recovery.
Okay, so Ms. Trammell, you can answer that question, and then Ms. Lynch, you can ask your follow-up question. Just make sure it's inside the scope.
Yes, it is.
I don't have the statute in front of me, Ms. Lynch. I'm happy to look at it with you to answer your questions better.
Okay.
But I don't have a copy of it with me, a paper copy.
And you don't have access on your computer to pull it up. In any case, I was just, has the company discussed 62.16.4D and put the potential to open an additional docket for the renewable energy facilities that the company is using to comply or over comply with the RPS, to explore, the potential for incentives that the company could earn for capital investments or other costs associated with renewable energy acquisition.
I object. I still am not sure how this relates to follow up on the hearing examiner's questions.
It relates because we're discussing the costs associated with the acquisition of
Ms.
renewable
Lynch,
energy
stop,
facilities. Yes.
please. We're generally discussing these costs in every part of this case. Can you relate your question back specifically to something either hearing examiner Ryan or I asked?
Well, I mean, specifically, the company is proposing cost recovery for the hail and sag for the facilities proposed here, and they've also proposed the use of hail and Sagamore. And I'm just, since costs have come up in the context of your conversation here, I'm wondering, has the company explored the potential to open a docket for the 252 resources, or for resources that over comply with the RPS to, I think bonds came up in the context of this conversation, and there could be financial incentives that exist for the company if they were to potentially open another docket, or,
Okay,
I think.
so then I guess, Ms. Trammell, I'll allow you to answer specifically Ms. Lynch's question. Has the company considered opening such a docket as she's explaining?
Not in the context of its requests in this RPS proceeding.
Well, Ms. Lynch, I think on some level, I get this is more just a discussion. I think that we can address in briefing too. I mean, the point you're making, to the extent to which you're saying, look, the actual REA itself says that there should be mechanisms that the commission utilizes to ensure not only compliance, but then going above and beyond where possible. I hadn't thought about that as like, there's been a lot of discussion today about what's the most appropriate function for collection of these costs and how do we do that. And perhaps your point that you're making is really a briefing one, which is to say, like, look, the legislature embedded into the statute itself, these clear recognition that incentives should be created. So therefore, I mean, why isn't that sort of exactly what SPS is doing here? That's what it seems. That's what I'm discerning from your discussion.
Correct.
So I think you can brief that. I mean, I think that's a perfectly good argument to put into briefing. And we'll just absorb that, and I'm sure we'll see responses from the interveners who oppose the collection through the mechanism.
Okay, thank you.
Yep.
Do you have any more questions, Ms. Lynch?
No, that was the extent of it. Thanks.
Okay, thank you. Ms. Hardy, redirect.
Your Honor, I will have some redirect, I believe, for Ms. Trammell, but it might be most efficient if we could take a lunch break now, and I can look at my notes, and that might cut down on the amount of questions I have for her.
I think that seems like a good idea to me. Hearing examiner Ryan, thumbs
Yep.
up. Okay, so let's take an hour for lunch, and then we'll do redirect for Ms. Trammell and move on to the next SPS witness. It's 11:45. So why don't we plan to reconvene? Let's reconvene at like 12:50. Give us a few extra minutes. Does that sound okay? All right, we'll see everybody in about an hour.
Thank you.
Thank you, Your Honor.
And remember, the YouTube is still streaming even when we're not on. All right, Ms. Gonzalez, when you're ready.
Yeah, I'm ready. I'm
Okay,
ready.
Great. All right. The time is 12:50. We are back on the record. And I believe Ms. Hardy was going to conduct her redirect of witness Trammell. Ms. Hardy?
Yes, thank you. Ms. Trammell, you were asked quite a few questions regarding base rate recovery versus rider recovery. If SPS recovers through the rider, does the true up ensure that SPS will only recover its actual costs?
Yes.
In New Mexico, is there any true up of cost recovered through base rates?
No.
If SPS recovers the cost of the solar projects through the rider, will it present the cost for review on an annual basis?
Yes, it would. Both the ongoing invested capital as well as the O&M expense and other components of the revenue requirement would be presented and reviewed annually in the RPS process.
Regarding base rate recovery, does SPS expect to file a base rate case every year?
No, we do not.
So will SPS incurred cost receive more frequent review if they are recovered through the rider than if they were recovered through base rates?
Yes, they would. Essentially, we'll be presenting those costs every year that the RECs from those facilities are being retired or banked for RPS compliance. So assuming, say, the project was utilized for RPS compliance in every year of its service life, with a service life of 35 years, that would be a presentation of those costs 35 times versus, say, like a base rate case scenario where if SPS filed a rate case every 5 years, those costs would receive review maybe every 7 years or, on a periodic basis. And that's material because with respect to O&M and expense recovery, there could be periods of time that aren't in test years in base rate case proceedings and level of costs, therefore that go unrecovered from a base rate proceeding perspective. Because that review will be occurring so much more frequently in the rider, that's where cost and investment risk is actually higher or could be higher in the rider mechanism than in base rates because of the more frequent review of costs that might otherwise not be reviewed in a base rate case scenario.
Do you recall being asked questions regarding rider recovery in relation to customer benefits?
Yes.
Will customers receive fuel savings when the solar projects go into service?
Yes, because the solar projects have no fuel cost associated with them. Generation from production off the facilities will have, all else equal, the impact of lowering system average fuel costs for customers as soon as generation begins.
And regarding production tax credits, has SPS proposed to provide the PTCs to customers when cost recovery begins for the solar projects?
Yes, we have.
And if SPS recovers the cost of the solar projects through the rider, will PTCs be provided to customers earlier than if SPS recovers the cost of the solar projects through base rates?
Yes, they would if approved in the 2026 RPS rider.
Hearing Examiner Barrett asked you some questions regarding RPS determinations in the CCN case that involved the solar projects. Do you recall those questions?
I do.
Do regulatory timing requirements impact when different resources are presented for PRC approval?
Yes, and those timing requirements apply, in my opinion, equally between self-build projects and developer projects or PPAs. So, for example, when we're selecting resources in the resource planning process, the IRP process is, as we discussed earlier today, ownership agnostic as well as technology agnostic. So we could have self-build projects and PPA projects coming out of an IRP. Usually, the projects selected out of an IRP go into the next step of the regulatory process, which is project approval or resource approvals. For a self-build project, that's a CCN. For a PPA project, that's a PPA approval filing, which is required in New Mexico before a PPA can be effectuated. Oftentimes, those resource approval filings can predate the filing of an RPS case where those projects could be presented for RPS compliance, whether it's a self-build project or a PPA project. So essentially, we have a very similar process where resources might be selected in an IRP. They go forward to resource approval filings. Again, self-build CCN, PPA would be PPA approval filing, and then go to the RPS case for demonstration of RPS compliance. So the cadence that the self-build solar projects have followed from solicitation to resource approval now to RPS case is very similar to the cadence that a PPA would follow under New Mexico regulatory frameworks. The only instance where some of those steps and timing considerations might be different is if the resources were approved closer to their in-service date, and potentially the CCN or the PPA pre-approval, depending on the ownership structure, might be included in the RPS case, again, just necessitating that project approval before ISD under the requirements of New Mexico CCN and PPA pre-approval rules.
Thank you. I have no further questions for Ms. Trammell.
All right. Hearing Examiner Ryan, anything further for Mr. Trammell?
Nope.
Thank you very much. Ms. Trammell, your testimony has been very helpful and complicated, so we appreciate your patience.
Well, didn't intend for our presentation to be complicated, but appreciate the in-depth review. Thank you all.
All right. So SPS, you can call your next witness.
Thank you. SPS's next witness is Justin Gable. We're just making sure that he is.
Has he been admitted?
Yep. He's
Okay.
there.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good afternoon, Mr. Gable.
Good afternoon.
Can you please state your name for the record?
My name is Justin Gable.
By whom are you employed and in what capacity?
I'm employed by Excel Energy, Southwestern Public Service Company. I'm the Director of Resource Planning.
Do you have a document in front of you that's marked as SPS Exhibit 3?
Yes.
Can you identify that document, please?
Yes, this is my direct testimony of Justin Gable on behalf of Southwest Public Service Company.
And does it include testimony attachments?
Yes, it does.
Are the testimony and attachments true and correct?
Yes, ma'am.
If I asked you the questions included in your direct testimony today, would your answers be the same?
Yes, ma'am.
Hearing examiners, I move the admission of SPS Exhibit 3.
And just for clarity's sake, Mr. Gable has adopted Ms. Couples' testimony as his own, correct?
Yes,
That
ma'am.
is correct.
Okay, I just wanted to make sure. Are there any objections to the admission of SPS Exhibit 3? Hearing no objections, the Exhibit 3 is admitted.
Thank you. I have no further questions for Mr. Gable. He's available for cross-examination. Thank you.
Thank you. OPL, do you have any questions for Mr. Gable?
I'm sorry, I didn't hear that.
I believe you're still muted, Mr. McMillan.
Can you hear me now?
You're a bit fuzzy.
Well, no, Your Honor, and I'll work on my audio situation.
So no questions? Okay, great. New Mexico Department of Justice.
Yes, Madam Hearing Examiner, I have a few questions.
All right, go ahead.
Good afternoon, Mr. Gable.
Good afternoon.
Let me just get set up here. If you would turn to page 14 of direct.
Okay, I'm on page 14.
And on lines 3 to 6, you're discussing SPS's projections as far as RECs go. And I wanted to make sure I understood, are you projecting a shortfall beginning in 27?
Yes, SPS is projecting a shortfall beginning in 27.
Okay, and there's two different types of projections that were used, and I was wondering if you could explain to me the difference between the financial forecast load and the planning load forecast.
Yes, sir. On page 15 of my testimony, lines 1 through 13 explain that. The financial forecast and the difference between the financial and the planning forecast. The planning forecast is a more long-term forecast that takes into account projections for increased economic development and load growth over the financial forecast.
And the financial forecast is, what you explain to me in layman's term what the financial forecast takes into account?
The financial forecast doesn't take into account the same levels of industrial and economic development.
So whichever model you use materially impacts whether, for instance, the 2026 SPS solar projects are necessary or not for purposes of the 27 compliance. Would that be fair to say?
I think it's fair to say that the solar projects, both the 26 and 27 solar projects, are required for RPS compliance for long-term planning long-term planning.
So when I guess materially, when I say materially impacts, it's the same. The determination is the same under either forecasting model.
Under both forecasting models, the solar projects that are selected for the 26 and 27 time periods are required.
Okay. On page 13, line 7, I guess it's starting at line 17 that continues on to the next. You say using the planning load forecast, SPS will rely on banked RECs to meet RPS compliance starting in 26. Would this approach deplete RECs that are in reserve and potentially create exposure to a shortfall in the future?
I guess I'm not quite sure about your question. I mean, we do rely on the banked RECs starting in 26. And using banked RECs does deplete them.
So have you looked at the rate of depletion under various load growth scenarios, like such as through a sensitivity analysis?
I don't know that we've done a sensitivity analysis, but we do present in the exhibits and attachments JLG 1, 2, and 3, the different scenarios that we have for the planning forecast and financial forecast.
Okay. On page 15, and I think we were just here, you testify that SPS is projecting compliance through 26, but non-compliance starting in 27, based on the planning forecast. Would you agree most of this projected shortfall is based on low growth assumptions?
Can you say that one more time?
Sure. So here you're testifying that it seems as if starting in 2027, you'll be in a phase of potential non-compliance. And that's based on a planning forecast. So my question is, would you agree most of the projected shortfall stems from your load growth assumptions?
If you compare the different forecasts and our resultant positions in 27, you can see that, yes, the planning forecast indicates that we are deficient, and the financial forecast shows that we are sufficient, but only marginally, a very small amount.
So on staying on the subject of load growth, if we move to 16, and here you're talking about material impacts to load forecasts on lines 1 through 11. And you explain that new customer load is now delayed to 2027 due to transmission constraints. If new load does not materialize as forecasted, SPS may not have a REC shortfall in 27. Would that be correct?
I would say that the only projections of load forecasting that I've provided are both a planning and financial forecast. I haven't developed a forecast scenario that assumes a certain amount of reduction based upon what I've written on page 16.
I'm not sure I understand what you said. You have not you've not looked at other scenarios. Is that essentially what you're saying, other than what you've provided?
We provide the planning forecast and the financial forecast and the situation described on page 16, where we talk about other material impacts. We highlight those material impacts, but we have not necessarily developed a scenario that that speculates on what that would look like.
That being a load forecast or load that doesn't materialize, less than what you've projected as far as load growth.
Correct.
Okay. Would you agree that RPS compliance for 27 is uncertain, depending on what sort of growth might materialize?
It's my opinion, it's fairly certain. For the planning forecast, we're showing deficient. And go ahead.
Oh, I was going to ask, what about external infrastructure development? Is that a variable that could impact it?
Could you maybe give me an example?
Interconnections, transmission line growth. I mean, all the things that would come into play to facilitate load growth.
There are other material changes that could happen that could affect our load projections. At the time of the development of these forecasts, we used the most likely scenarios that SPS believed were possible. But there are material changes that could happen.
Just out of curiosity, do you revise or revisit these projections on a certain basis or regular basis?
Yes, we do load forecast updates.
When would be the next load forecast update?
I would expect one to be done this year.
And according to attachment SC1, community solar contributes RECs beginning in 26. Are you aware if any of these facilities have received final approvals and interconnection agreements?
Let me get there real quick. So you're saying attachment 1 and you're asking
SC1,
about
attachment 1, I believe it's PDF page 22. So I see you might be looking at the physical document 21.
okay, and you're asking about
I was asking about the community solar RECs beginning in 26. And my question was if you're aware if any of these facilities have received final approval and interconnection agreements.
I don't have that information in front of me right now.
Okay. And you've looked at all 3 pages. I'm just asking, right? There's 3 pages of,
Yes, sir.
okay.
I'm assuming you mean on the second
2
page
of 3, yeah.
Line 26, the community
Yes.
solar facilities. Yes.
Okay. So, but you do have a document that shows the status of those community solar facilities that are
I would
projected.
have to go back and check. I would need to go back and check. I don't know that information right now off the top of my head.
Okay. But if any of those facilities or projects are delayed or if they underperform, that could impact SPS's REC shortfall in 27. Is that correct?
I would say like all projections, there's a potential for them to underperform as compared to what we forecast.
Okay. And if it underperformed, it would impact the shortfall.
It would increase our shortfall.
Okay. I have no further questions. Thank you very much, sir.
Thank you.
I actually have a couple clarifying questions. When you first started having your conversation with Mr. Elliott, you explained the SPS provided the 2 different forecasts, and to be perfectly candid, I'm still not entirely sure what the difference is between the 2. Can you explain to me in layman's terms, and I'm not talking about long-term forecast, I'm talking about the difference. How do these 2 forecasts create different projections just through 2027?
I'd have to go and look at the attachments, but the financial forecast and the projection, and the planning forecast, actually fairly closely aligned in the near term. And then over time, they differ. But the financial forecast is a much more conservative view of load growth. And the planning forecast takes into account a higher expectation of electrification and industrial growth.
And thank you, that helps. And if I'm understanding correctly, one of these forecasts shows a REC deficit in 2027, and one of them shows by a narrow margin that you will achieve your REC requirements in 2027. Is that correct?
Yes.
So then I guess my question is, at one point, Mr. Elliott asked you if you would characterize whether or not SPS is going to be in a rec deficit in 2027 as uncertain. I don't know how you can say that it's not uncertain when you've got two separate load forecasts. You've got substantial questions about community solar and transmission constraints. How is SPS certain that they are going to, if I'm understanding correctly, you're certain that you're going to be in a deficit and therefore need these facilities in 2027? How can you be certain with all of those variables?
There are a number of variables. What I would say is that are these resources certain to be required for future compliance? They are. Even after 27, in 28, we are showing deficit. In 25, I'm sorry, in 27, the narrow margin of 250, it's a very tight margin. The planning forecast is the forecast that we use and we represent here as our target. That's why I say that is the forecast that I'm planning to in resource planning. And that's why I would say I'm certain that we need these resources, because that's my planning target. And that planning target is showing deficient in 2027.
Then why did you provide two?
In the last case, we actually we were expected to only provide planning forecasts going forward, and the commission asked us to provide the financial for informational purposes.
Okay, thank you. Mr. Elliott, any more questions? All right. Moving on, Ms. Lynch, do you have any questions for Mr. Gable?
I do not, Your Honor.
All right, thank you. New Mexico Large Customer Group, Mr. Stoffel.
Thank you. I think just one question. Good afternoon, Mr. Gable.
Good afternoon.
So just to be clear, neither the 2026 nor 2027 SPS solar projects were selected solely to comply with the state's renewable portfolio standard, correct?
They were not selected to comply with solely for the New Mexico renewable portfolio standard, correct?
Thank you. No further questions.
Great. Anything from Ms. Drake?
Not from me, thank you.
You're welcome. Does staff have any questions?
No questions from staff. Thank you.
Great. Hearing Examiner Ryan.
Just following up on the question that was just asked a moment ago, the selection of the projects, if not entirely for RPS, what were the other criteria utilized to select them? Or what was the other functions they were intended to serve?
Capacity.
And just for my own clarification, the capacity, when you use the term capacity, you're talking about peak load scenarios where you have to meet high levels of demand that necessitate demand charge kind of a circumstance. Is that I'm genuinely asking you to explain that in greater detail.
Yes, SPS has to have sufficient capacity of resources to meet its peak load demand. These resources help meet that.
Is there any way to differentiate, like how much of it would we be correct to say that if only 4% will go towards rec usage, that it's then, well, as Ms. Tremmel said earlier, that the other 90+%, whatever the number would be, like it's more than 90%, would go towards capacity, but you'll bank the recs, or is that not the way to think about it?
I think I would say that resources can have a number of attributes that benefit our system. These resources have multiple benefits. In this, in relationship to this RPS requirement, they do generate RECs, and I think that is one attribute that provides value. They also provide capacity value. I don't know that they can be necessarily separated out and give a quantified value of how they're serving each one.
Okay, no, that was interesting. That's all the questions I have for the witness, Ms. Barrett.
Right, thank you. And Mr. Gable, I already asked you my questions, so I don't actually have any more for you at this time. Does anyone have any further questions based on the question hearing examiner Ryan just asked? And does SPS have redirect?
I do just have one question.
Go ahead.
Yeah. Mr. Gable, regarding the two different forecasts, SPS has a current IRP process going on, correct?
Yes, ma'am.
And could that process result in the selection of additional capacity and energy resources that would allow more load to come on SPS's system in 2027?
It is possible. This RFP is for 27 to 2030.
And if additional load comes onto SPS's system, would that increase SPS's RPS compliance needs?
Yes, ma'am.
Those are my questions. Thank you.
All right. Well, if there's nothing further, thank you very much, Mr. Gable, for your testimony. It was very helpful.
Thank you.
You may be excused. And I believe SPS next witness, Mr. Rurup, is that how you say it?
Yes, that is how you say it.
Okay.
And he's transitioning into the room now.
Sure, of course.
Raise your right hand, sir. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And Mr. Purcell, I'm assuming since I can see your face, you're going to be providing the direct examination?
Yes, Your Honor, I will be.
All right, go ahead.
Okay. Mr. Rurup, can you please state your full name for the record, please?
Jason Rurup.
And by whom are you employed and what is your position?
Excel Energy Services as a manager of energy supply and market modeling.
And do you have with you what is marked as SPS Exhibit 4?
I do.
And can you identify what SPS Exhibit 4 is for the record?
It is my direct testimony in this proceeding dated April 1st, 2025.
And does your direct testimony have any attachments?
Yes, it does.
Okay. And is this a true and correct copy of your direct testimony and attachments?
Yes.
And if I read or asked you the questions in that direct testimony here today, would your answers be the same?
Yes.
With that, Your Honor, I would move for the admission of SPS Exhibit 4?
I think just one more question, Mr. Rurup. Was this testimony and exhibits prepared by you or under your direct supervision?
Yes.
All right. Are there any objections to the admission of SPS Exhibit 4? Hearing no objections, the exhibit is admitted.
And Mr. Rurup, do you have what's marked as SPS Exhibit 5?
I do.
Can you identify what SPS Exhibit 5 is?
Yes, it is my rebuttal testimony in this proceeding dated June 4th, 2025.
And does your rebuttal testimony have any attachments?
Yes.
And was this rebuttal testimony and attachments prepared by you or under your direct supervision?
Yes.
And is this a true and correct top copy of your rebuttal testimony?
It is.
Attachment? Okay.
Sorry, it is.
Oh, no problem. And if I asked you the questions here today in your rebuttal testimony, would your answers be the same?
They would.
Thank you, Mr. Rurup. With that, I would move for the admission of SPS Exhibit 5.
Are there any objections to the admission of Exhibit 5? Hearing no objections, the exhibit is admitted.
And with that, I would tender Mr. Rurup for cross-examination.
All right, thank you. Mr. McMillan, do you have questions?
No, Your Honor.
All right, thank you. Ms. Drake.
Yes, ma'am, I do have questions.
Go ahead.
Is this the right order, though? I'm not sure if there's
Are you
anybody
OPL
else.
or LES?
I'm LES.
Oh, I'm sorry. Who's OPL?
That was
Mr.
Mr.
Stock?
McMillan.
Mr. McMillan,
OPL.
I'm sorry. I'm sorry. I just got my acronyms mixed up. Mr. Elliott, NMDOJ. You're next in order. Thank you for
Thank you,
setting
Madam
this.
Hearing Examiner. Good afternoon, sir.
Good afternoon, Mr. Elliott.
If you would please turn to page 23 of your direct testimony.
Sure.
On lines 3 through 6, you discuss how the 2026 solar projects are allocated. And my question is, would you agree that the existing RPS costs are allocated on an energy basis, while the 26 solar project costs are allocated on a demand basis?
Yes, that's generally true. Yep.
Okay. And is it also correct that the existing RPS costs result in a uniform rate across customer classes?
Yes.
But the 2026 projects will create class-specific rates. Am I understanding that correctly?
You are.
Okay. If you would turn to page 26, this is where you discuss the demand allocator.
Okay.
And the 4CP production allocator for the 26 solar projects. This is an allocator that was approved in prior general rate cases. Is right?
Yes.
Okay. But they weren't, but not in an RPS rider proceeding. Is that right?
To my knowledge, this is the first time SPS has proposed to do a demand allocator for costs within the RPS cost rider.
Okay. And I think it's referenced on page 22, but is it true that the SPS, the 26 solar projects are approximately $14.9 million of the RPS revenue requirement?
Yes, that's on page 22 of my testimony.
Okay. So would the addition of these solar projects cause an increase in the RPS charge for every customer class?
Yes.
Okay. So if you would turn to page 45.
Okay.
And I just want to make sure I understand this. On lines 5 through 10, do I understand correctly that this is saying the cost of the SPS solar projects will be trued up by customer class? Is that right?
For the SPS 2026 solar projects, our proposal is that the revenue requirement or versus, actual costs versus the revenue received would be trued up by customer class. Yes.
Does that create a risk of causing intra-class subsidies?
How so? No, I don't believe so.
Well, if it's trued up, it would be trued up for all classes. Well, I guess if you could explain the process for truing it up, perhaps that would help. Will it be?
So, yeah, sure. That's sort of a core part of my testimony, but I can generally explain that our proposal is that there's the RPS cost writer charge to each class is $1 per kWh charge. That's basically two components. It's the existing RPS costs and the portion or component, and then an additional component, which is the SPS 2026 solar projects component. Add those two together, that's the total RPS cost writer charge per customer class. And so when revenue came in the door for each customer, that revenue would be split basically into those same two components. And therefore, when we reconcile a year, we would know how much revenue we received for each customer class going toward the revenue requirement of the SPS 2026 solar projects, and therefore we could do the true up calculations with that method.
So if there's an under collection in 26 for the residential customer class, that deficit would be applied to the future year?
That deficit would be, yes. So in general, for instance, we're truing up 2024 right now for costs, and then that is included in the 2026 rate. And so, yeah, if we had an under collection for residential in 2026, when we're reconciling in 2027, that would be collected from residential customers in let's see, where am I getting lost here? 25, 26, and 27, I believe. Yeah, no, sorry, 28. Is that right? Yeah, 28.
Okay. So if there is that deficit in 26, it would be made up by I don't want to say borrowing, but I mean, you still have to make the revenue requirement whole. So how do you avoid the intra-class subsidization for that period? Is it just simply that accounting mechanism of saying there's a deficit in the future year, and so?
Well, the under collected balance in this example would have an interest charge associated with it. It's at a customer deposit interest rate approved by the commission, and that would be included in the calculation of the true up.
Thank you. I'm gonna go back to page 29.
Okay.
And this is the table JAR4, the comparison of load forecasts.
Yes.
And you relied on this to forecast the 2026 costs. How confident are you that the load shares by class are going to stay the same or remain consistent?
So you're asking, can you relate the question to table JAR4 for me just a little bit better?
So I'm looking at the 24 load forecast, and you're using that to forecast 26. Is that correct?
Correct. That column, second column there in JAR4 is a forecast of 2026. Yeah.
Okay.
It's labeled 2024 load forecast, but it's a forecast of 2026. Correct.
Okay. So I guess my question is, the question is, how confident are you that the shares by class, residential heating, so forth, are going to stay the same or remain consistent going forward?
Well, our true up process doesn't require the forecast to stay consistent over time.
Okay. Because it's a true up. Is that?
That's correct.
Okay. My next question is about page 31.
Okay.
And on lines 3 through 7, you talk about updating the 4CP production from the 2022 rate case with more recent information. And my question is, would you agree if the actual load shifts substantially from your forecast, that the allocations may no longer reflect cost causation?
Well, I would say that the allocator itself reflects cost causation. It's based on cost causation principles. And we're putting forward a defendable forecast of 2026 in calculating these allocators using the method of the AED4CP.
Is there a tolerance level for reviewing those allocators, the demand allocator, at which point you say the forecast has changed sufficiently that we now need to reevaluate the allocator?
So are you referring to it in the true up process or the forecast process?
I think the forecast process.
Okay. And so like you're saying, before these rates would go into effect in 2026, would we want to do another forecast of 2026?
Well, I was asking more just in a general manner as a practitioner, as an expert, if there's a tolerance level beyond which you start thinking we have to revisit our forecast. So if the load forecast in this case is well, let me just ask it this way, make it simple for myself. What's the variance that you're willing to accept in load forecasts for the purpose of allocating cost to customer classes? If suddenly we see like a huge jump in forecasted demand that's even greater than what we have, or a reduction in forecasted demand, how much of a reduction or increase would it take for you to revisit?
Well, I would say that our true up process would handle the deviations from our forecast.
So that's the backstop, in effect, the true up.
a backstop to the deviations from a perfect forecast.
Yeah,
I'll accept that terminology, sure.
okay, that helps me. Okay, so on page 42,
okay,
if we could jump forward again. And this is in reference to lines 5 through 12. How will SPS, how will the project costs be reconciled? And sort of a follow-up to my last question. But what safeguards does SPS have to protect against over recovery if customer loads decline unexpectedly?
Over recovery if loads decline. Well, if I'm confused by the question. If loads decline, I would assume we would have less sales, which would be less revenue.
True, but what if it, I guess maybe I'm thinking here about, could there be over recovery amongst a certain class relative to another? If load decline
Sure.
drop precipitously?
Oh, I don't know in that context, but in general, we could have some classes that are over and some classes that are under recovered.
So what would be the safeguard then in those circumstances?
I don't understand what the safeguard.
I guess it would be the true up, right? Would the true up be the safeguard in that case?
Of neither over or under collecting
Yeah,
the costs of the projects. Yes, the true up is the protection to customers of neither over recovery. Yes.
Okay. So let me just maybe flesh out that thought more. But if there was an economic downturn and large customer load declined unexpectedly, over recovery or from residential class there would be a mitigation there via the true up. Am I understanding how that would work correctly?
I may need you to develop that question just a little bit more for me.
Let's not develop it. I'm just going to move on. Sometimes I have questions that exceed my own understanding. Okay, so my last question here is just about page 45 of your testimony.
Okay.
And I think I understand on 1 through 10, lines 1 through 10 of page 45, you're proposing to reconcile the 2026 solar project costs on a class by class basis. And my question is, has SPS done that before in New Mexico?
For an owned solar project or?
Yes.
Not to my knowledge. Although I don't know if we've had an owned solar project before either.
Did it do that with Hale and Sagamore? Do you know?
No, we don't Hale and Sagamore on base rates.
Okay, thank you. So by allocating it on a class by class basis, does this create any risk for bill fluctuations for customers?
You mean to well, we do plan on truing up costs, but those should be relatively unimpactful, I would say, with this methodology.
So, yeah, I guess the question I was thinking about is, will the bill impact be consistent on a month-to-month basis, or does by allocating it on this basis increased fluctuation customers might see in their bills?
I'd say since we true it up over an entire year, the impacts are muted.
Okay. Well, but if you're doing it over a year-to-year, on a year-to-year basis, those costs will look different if I compared 26 to 25 and 27 to 26. Is that a fair statement?
Which costs, sir?
The RPS, the solar project costs that are going to be allocated on a class-by-class basis. If you compared those, since they're being trued up on an annual basis, if I looked at my bill, I don't know if I don't get an end of year statement to the best of my knowledge, but if I did and I looked at 25 and compared it to 24 or 26 and compared it to 25, I would see a significant difference.
You're talking about SPS's RPS cost writer, how it's changed over time? Well, I do compare our rate proposed for 26 to the 25 rate. That's in my testimony. I think in general, I'm showing that the bill impact is just under 2% of our proposal, but that does not include the PTC benefit that customers would receive in the FPPCAC.
So could I describe that as volatility in the RPS charge from a year-to-year basis?
I wouldn't describe it as volatility. I would.
Okay. I don't have any more questions. I thank you for your time and indulging me in those questions.
Thank you, sir.
If I could just ask one follow-up question based on what Mr. Elliott just asked, it occurred to me to inquire, Mr. Rurup, do we have in the record, I mean, there's been lots of discussions about the production tax credits, and if they go away, what's the impact? Obviously SPS doesn't control whether or not those things continue existing or go away. But do we know the impact on rates if they do go away?
I haven't done that analysis. My analysis just shows the impacts on the RPS cost writer and the overall rate impact to customers, which is just under 2%. But that does not include the PTC benefit that they would receive offsetting fuel costs in the FPPCAC. So these impacts are, well, I guess that was your kind of the basis of your question. Sorry. So
no, that's okay. I guess my point was, we were having a lot of discussion about production tax credits here, and I just want to know, like, what is the actual on the ground impact for the ratepayers in terms of whether those are offered or not.
So I guess to answer your question, my bill impact analysis doesn't include the impact of the PTC. So that would give you some idea of the rate impact without PTCs.
Okay. All right. Thank you.
Sure.
All right. Thank you, Mr. Elliott. Ms. Lynch, do you have any questions?
I do not have any.
All right, thank you. Mr. Stoffel.
No questions, thank you.
Ms. Drake, I think you already indicated that you don't have any questions.
Yes, I do have some.
Oh, you do
questions.
have some. My goodness.
Yeah,
okay,
I do.
Please go ahead.
Thank you. Thank you. Mr. Rurup, good afternoon.
Ms. Drake, pleasure to see you.
Good to see you too. So I have some questions for you. I hope you can help us understand something about these uneconomic costs of the Sun E projects. And let me ask you first, do you call them Sun E or Sun Ed or what?
Let's go with Sunny.
Sun E. Okay, you got it.
That's
We'll
sun
go
with a
with
capital E.
right,
Okay.
exactly. If you could look at your rebuttal testimony, which I believe is your exhibit 5, and if you
Yes.
could, excuse me, if you could turn to page 5 of that, and that would be page 9 of the PDF, but page 5 according to the page numbers at the bottom of the page.
I've got it.
Okay, so in this section, you address Mr. Gorman's testimony regarding these Sun E uneconomic costs. Is that right?
It is.
Okay, and first on line 3, or I guess on lines 2 to 3, you characterize the Sun E uneconomic costs as the costs that are above market cost. Is that right?
That is, yes, that's what that says.
Okay. And I know these Sun E uneconomic costs have been
Well,
around for a while. Is it your
my apologies.
Yeah.
I think I'm characterizing Mr. Gorman's testimony there. That's
Okay.
just as a clarification.
Okay, thank you, sir. That's great.
I
Thanks.
apologize for interrupting.
Sure, no worries. Is it your understanding that the Sun E uneconomic costs were first approved to be put through the RPS rider about 10 years ago?
I would, yes, doing a little research, it's at least that old.
Yeah. In your footnote 7 on at the bottom of page 5, you identify that commission case was case number 14-00198-UT. Is that right?
Yes.
And is it your understanding that that was a stipulated settlement in which the commission approved the stipulation overall? Is that right?
You know, I don't have a lot of firsthand knowledge. I was just generally trying to, in footnote 7, I was just generally trying to say that this practice has been in place a long time. And I can say I did not review the whole procedural history of that noted case.
That's fine, sir. If you don't know, then you don't know. That's fine. Let me ask one more that you likely might not know. Do you know when the Sun E PPAs themselves were first approved by the commission? Was that in 2010?
I don't know.
Okay, that's fine, sir. And in the current 2025 case that we're in right now, the amount of the uneconomic Sun E costs that SPS is requesting to put through the 2026 rider is about $12 million. Is that correct?
That would be, I think, in one of my attachments. So let me just get there real fast. I mean, subject to check. I'll yeah, accept that. Yeah.
Oh, okay. Well, we can, if you'd like, we can go to Ms. Trammell's exhibit BAT-3.
Oh, that's okay. It's in my attachment 1, and I see
Okay.
the number there, approximately
Okay.
$12 million. Yeah.
Right. And it looks like, and I was looking at Ms. Trammell's testimony as well, but it looks like these Sun E costs have been increasing over the years. Is that right?
I haven't done that analysis to be able to tell you, Ms. Drake.
Okay. All right, that's fine. That's fine. No worries. I think that's in Ms. Trammell's exhibits, but that's okay. We've got it in her exhibits. Do you happen to know if any of the increases in the Sun E uneconomic costs are a result of a cost escalator in the original PPAs? Do you have any information on that?
I do believe the PPAs escalate over time. I don't know
Okay,
how
do
much
you-
per year, but they
Okay,
do. I do believe they do escalate. Yeah.
okay. Do you know what those initial Sun E uneconomic costs were that were first approved to be put through the rider in the 2014 case?
I don't.
Okay, all right. And you don't know then how much they've increased over the years since then?
I don't. I think from what I know of the methodology of how those uneconomic costs are determined, it could also depend on market conditions.
Okay, all right. If you could look at your attachment JAR1,
Got it?
and I believe that's in your direct testimony, correct?
Yes, ma'am.
Okay, and if you could look at page 1 of 2, and that's on page 59 of the PDF.
Okay.
Are you there?
Believe so.
Okay, cool. It looks to me like this page breaks down your 2026 plan year revenue requirement into 3 categories or buckets, is that right?
Okay, so you're on page 1 of the 1 of 2?
Correct,
Yep,
correct.
that's correct.
Okay, so so lines, if you look at line 6 through 14, they show the costs included in your 2026 projected existing RPS annual costs, correct?
Yes.
And if you look at line 10, that's the line that shows the Sun E uneconomic costs, is that right?
Yes, that's the value we were talking about earlier, approximately $12 million.
Right. And so if you go down to, I think it's line 14, that shows the total for that bucket of costs. Is that right? And
Yes,
that's
ma'am.
about 13.5
Yes, ma'am.
million, about that?
Yep.
Okay. So it looks like from this that those Sun E uneconomic costs are close to about 90% of the existing RPS costs bucket, if you will. Is that right?
Yeah, I trust your math on that. It looks to be around there.
All right, well, I wouldn't recommend you trust the math of any lawyer, but it sounds about right.
It does.
Okay, cool. If you could then go back to your rebuttal testimony, page 5,
Okay.
and there you state that you don't agree with Mr. Gorman regarding the allocation of those Sun E uneconomic costs, right? And
I
that's,
don't.
sorry, that's, I would direct you to, well, it looks like it's around lines 9 through 13. Is that right?
Yes.
And to be clear, what you're speaking of here is the allocation of costs among rate classes, correct?
That's correct. Mr. Gorman is not disputing what we've calculated as the uneconomic cost. He's just recommending that instead of existing treatment of it, which is been approved and our practice in the RPS cost rider going back to whenever we can think back to, going back to at least 2015. It's been continually in a energy allocation. He's proposing now to make it demand allocated.
Yeah, and I understand that on lines 11 through 13, you disagree with him because those Sun E uneconomic costs have been determined to be energy related by virtue of being included in the RPS rider. Is that right?
The RECs themselves and the renewable energy nature of the projects, yes. The context of that is, we're making $1 per megawatt hour payment for renewable energy to the Sunny PPA.
Yeah. So can you point me to a commission decision in which the commission not only approved those Sun E uneconomic costs to be included in the RPS rider, but also expressly reviewed and approved the allocation methodology for those uneconomic costs?
Well, I think I would, if I understand your question correctly, it seems like the approval of every RPS cost rider since their inclusion in the uneconomic costs in the RPS cost rider have been approved by the commission as SPS has charged them on $1 per kWh basis on the energy allocation.
Do you happen to know if that was opposed in any case, since 2014?
I don't know the history on that.
That's fine. That's fine. Are you aware of any other cases in which the commission has approved an allocation for costs put through the rider other than on an energy basis?
I'm not.
Okay, well, thank you, sir. I appreciate your answers and your information. That's all I have. Thank you.
Thank you.
Thanks, Ms. Drake. And moving on to staff. Does staff have any questions?
Madam Hearing Examiner, staff has no questions for Mr. Rurup. Thank you.
All right, thank you. Hearing Examiner Ryan.
Just following up with what Ms. Drake was making inquiry about there, I just want to see if I can work something out in my mind. This is your rebuttal testimony at 5.
Okay.
If we move to, so where you're talking there about renewable energy related, the costs, the uneconomic costs of the Sunny purchase power agreement, you're saying those are renewable energy related, not demand related.
I'm sorry, could you restate that?
Sure. His testimony says, I would argue that the uneconomic costs of the Sun E power purchase agreement are renewable energy related, not demand related. And I'm wondering if when we get to the point of concentration where renewable energy constitutes all or virtually all of the generation portfolio by SPS, I mean, can we make these kinds of distinctions?
Well, this is a PPA that we pay on $1 per megawatt hour basis. We don't make a demand payment on this particular PPA. I mean, if we made a separate demand payment, that might have different rate making treatment. And so it's just generally saying that this is renewable energy that's paid on $1 per megawatt hour basis. And the decisions by the commission in the past has been to include these in the RPS cost rider. And I would add that all the RECs of this project are used for compliance.
Okay, if you just bear with me as I go through their testimonies to see where my questions are. In your direct testimony, table JAR4, I was just trying to understand. Oh, sorry, this is a page, it's numbered page 30 of your testimony.
No problem. JAR4.
Comparison of load forecasts.
Oh, table 4. Okay.
Excuse
Yeah.
me, yes.
Yep.
Table JAR4, yeah.
Give me just a second. We were on that one before. Do you have, oh, sorry, what was the page number?
That would be page number 30.
Okay. Okay, got it.
So the question I had was, why is it that the only increase we're seeing there in the forecast is with the primary general?
Yes, Your Honor. That was a comparison of the FTY used in our current base rates, which I believe was I think it was a FTY ending I can't remember actually the FTY period, but that was the load forecast included in that rate case. And from the work in that rate case, we did an analysis of the AED4CP allocation. And so this table is demonstrating that assumptions have changed since that time of that forecast, which was 2022. We're now in 25. We think 26 is going to look quite a bit different. We've had lots of growth in primary general, and that was the basis of saying we need to revisit the allocations from that rate case work to recognize that primary general is going to get a larger allocation than what we had assumed at that time.
And primary general is what kind of users?
These are very high load factor, 90% plus customers. I would assume they're oil and gas customers. You can see the load factors in some of my attachments. They're very high.
I'm just scanning the rest of this direct testimony. Okay, moving on to your rebuttal. When you page 4 of your rebuttal.
Okay.
Down on lines 11 through 14.
Yes.
I just was hoping you could explain to me the latter half of the statements there. Should now be determined to be demand related and as a result should be allocated. Could you just explain? And I've read these words and I think I have a general understanding, but why is that conclusion? How did you come to reach that conclusion and what is it? And again, I'm not just asking for a simple explanation.
Sure. So this is a characterization of Mr. Gorman's direct testimony where he said that $12 million that we were discussing with Ms. Drake should no longer be allocated the same way that we do all other RPS costs up to through I guess you would say 2025 of the RPS cost writer. We've always allocated based on energy. those costs. We introduced the AED 4CP demand allocation for the SPS 2026 solar projects. Mr. Gorman said, obviously did not agree that we should recover the SPS 2026 solar projects, but he liked the demand allocation idea and he wanted to shift those sunny uneconomic costs, which we've said are a lion's share of the existing RPS costs, as a demand allocator. And my testimony shows what the impacts of that would be when you move from an energy allocation to a demand allocation. It's going to shift costs from if you go from energy to demand, it's going to shift costs away from the lower load factor customers, which
Residential.
for us happen to be residential. And you can see the impacts there in table JAR. No, sorry. Yes, the impacts on the allocators are in JAR-R1, which is on page 8 of my testimony. And then my estimate of the cost shift is 1.1 million.
When you are talking, yeah, okay. No, that's okay. You finish your thought there, please.
Which is just simple math. It's, it's taken the 9% shift times the $12 million.
So if I understand correctly, the disagreement between yourself and Mr. Gorman reflects that you, with the introduction of the AED 4CP, you're attempting to make the rider more like what allocate the allocation more like what we would have if we were trying to deal with these in base rates, which is to spread the costs to the customers in the fashion like the cost causation dictates. So if we were to leave, and I'm trying to say this so I'll make sure I understand, I think your position ultimately is the residential class here shouldn't, under Mr. Gorman's position, which they seem to absorb costs. Like you're saying, effectively, we'd have to have the 4 AED CP because that's the appropriate way to think about who are driving the costs for these resources. Is that correct?
Yeah, so the SPS solar projects are sort of a fixed production cost.
Mm-hmm.
Unlike a PPA, we're not making $1 per megawatt hour payment to a third party or a counterparty. And so, yes, we're generally following the same rate making treatment that we would do in a base rate case for these costs. But the difference being that we're still proposing to create the charge on an energy basis for all classes in recognition that the RPS compliance is demonstrated on a kilowatt hour basis.
Right. Is that like, I mean, that's an interesting point. Is there any structural incompatibility there that we're like, the way you measure compliance with the RPS is through rec retirement, but when we think about, how do we spread costs among classes, you're generally looking at cost causation. I mean, is there a tension between those two basic concepts?
The cost allocation proposal is the demand allocator. And then within that class, we're proposing for the charge to be $1 per kWh for all customers within that class. However, I do say in my rebuttal that there's some merit that customers today that have demand charges for these type costs, the commission could decide that those costs, which are demand allocated to classes with demand charges, which is classes such as irrigation, secondary general, primary general, LGST, we could recover these on a demand charge as well.
And that was, I
Within-
remember, I
Yeah,
remember
go ahead.
reading that in your testimony, and the question I prompted was, well, why don't we? Like, I guess in some of when I read that part of your testimony, I said, what do we do with this? Or should we do something?
Well, our proposal is still that they should be charged on a dollar per kWh basis in recognition that customers with higher load factors require more renewable energy than customers with lower load factors to maintain RPS compliance.
And that's actually my next question I have for you and maybe perhaps I want to make sure I understand that. At page 6 of your rebuttal, maybe try to help me understand that concept that you're articulating at beginning at lines 2. So RPS compliance is demonstrated on a retail sales basis in kilowatt hours less voluntary program participants. Okay, I understand that. And then the next part, this means that high load factor customers, such as large general service transmission customers, require more renewable energy certificates for compliance than customers with lower load factors. And I guess ultimately, I was reading this and I'm like, wait a minute, it's SPS that has to retire the RECs in order to show compliance. And I'm not sure that I follow what you're saying here to say that particular customers require large, or are you just simply saying certain customers require more energy?
That's all I'm saying. The argument of charging these SPS solar projects either on an energy rate or a demand rate is articulated as intra-class subsidies from some of the expert witnesses. And I'm just saying our proposal is still recognizing that within a class, if a customer has a higher load factor, they're going to get a larger share of that class's revenue responsibility in recognition that they're driving more of the RPS need than the lower load factor customer. Just the fact that they're using more energy.
Well, in the RPS, I mean, to the extent to which we're saying there's something called an RPS need, I mean, that's, the company has a requirement to retire so many RECs per year, depending on their actual consumption and generation. So, I mean, are we having a discussion here in part about who should bear the cost of compliance with the Renewable Energy Act, and should high load factor customers have some additional burden because they are consuming more electricity?
They do today. I can tell you they do today. And that's why Mr. Gorman was trying to allocate costs on demand, because the high load factor customers, by nature of an energy allocation, are already receiving more of the costs on a per customer basis.
Because they're using more electricity in some ways that corresponds with the idea that if I'm just occurring as we're speaking, so I had to just think about all this. This is a good dialogue. Thank you.
Oh, you're welcome.
Just scanning through the rest of the rebuttal. So I guess ultimately, I understand the point to say that Mr. Gorman and the person and the clients are the individuals he represents, the client, and then it's like a consortium, whatever. Effectively, it's sort of his argument is sort of self-interested. But are you saying that you ultimately agree with him, and I know I may have asked you this just a few minutes ago, and I'm sorry if I'm repeating the question, but you say at page 17 of the rebuttal, SPS would need to include a new demand chart component in the cost rider.
Yeah.
for customer classes with demand rates. I guess where I'm left with all that is, are you saying that that's desirable, and then how do you do that if that's in fact desirable?
Okay, I think the first part of your question was, do I agree that the Sun E uneconomic costs should be demand allocated? And I don't. But in the context of the SPS 2026 solar projects, I mentioned that those, while they are demand allocated, just as we proposed the AD4CP, there are arguments that the rate design, so the cost allocation is demand, but the rate design, the charge to customers could be on an energy basis or a demand basis. But I would just reiterate that our proposal is that it should continue to be on an energy basis or an energy charge.
And that's most desirable because that's what the RPS measures, in that it is the retirement of a certain amount of volumetric consumption of energy that gets translated to RECs that are then retired.
Exactly.
Okay, thank you, Mr. Rupp. Those are my questions for you. Appreciate it.
Thank you, Your Honor.
Does anyone have any follow-up questions based on hearing examiner Ryan's questions? Because I actually don't have any further questions for you, Mr. Rupp. Anyone? Mr. Purcell, do you have redirect?
Yes, just one question. Mr. Rura, do you recall the conversation with Ms. Drake regarding whether the commission has specifically approved the use of an energy allocator in the past for the Sunny uneconomic costs?
I do.
Okay. Putting aside whether the commission has ever done that, is it your position that the commission could do so and specifically approve the use of an energy allocator in this case?
Yes.
Okay, thank you. That's all I have.
All right. Thank you for your testimony, Mr. Rurup, and the witness may be excused. This may be a good time to take our afternoon break. Hearing examiner Ryan, how long do you think?
I would just go to 15 minutes. I think everybody could use it.
Yeah, I agree. Why don't we, making me do math.
Just, yeah, we can just round it off to the, so what, add to 230, go back 240. How does that sound?
Let's go, we'll reconvene at 2:40.
And
Yep.
Madam Hearing Examiner, Mr. Hearing Examiner, when we return, will we be on Johnson?
Yes.
Okay, and then after that, I believe that would then be Miss Reno. Is that
That's
right?
correct.
Okay.
That's correct.
Thank you.
All right. We'll reconvene at 2:40. Thank you.
Hearing examiner.
Yes, ma'am.
I just wanted to share that I will not be here starting at 2:30.
Okay, thank you.
Okay, bye-bye.
Right. Ms. Gonzalez?
Yes, I'm ready.
All right. The time is 2:40 and we're back on the record. And SPS can call their next witness.
Thank you, Your Honor. SPS calls Allison Johnson to the stand. And she's already in there, so.
There,
Ms. Johnson, you can go ahead and be sworn in.
raise your hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ms. Johnson, can you please state your full name for the record?
Allison Johnson,
And by whom are you employed and what is your position?
Excel Energy Services as the manager of SPS revenue analysis.
And do you have with you what is marked as SPS Exhibit 6?
Yes, I do.
And can you identify that for the record?
It is my direct testimony in this proceeding.
And does that direct testimony have any attachments?
Yes, it does.
And was this direct testimony and the attachments prepared by you or under your direct supervision?
Yes,
And is this what we have marked as SPS Exhibit 6, a true and correct copy of that testimony and attachments?
it is.
And if I asked you all the questions that are in this direct testimony here today, would your answers be the same?
Yes.
With that, Your Honors, I move for the admission of SPS Exhibit 6.
Are there any objections to the admission of SPS Exhibit 6? Hearing no objections, Exhibit 6 is admitted.
And with that, Your Honors, I would tender Ms. Johnson for cross-examination.
Thank you. Mr. McMillan, do you have any questions for Ms. Johnson?
No questions from OPL, Your Honor.
All right, thank you. NMDOJ, Mr. Elliott.
No questions. Thank you.
All right, thank you. CCAE, Ms. Lynch. Oh, I'm sorry, Ms. Lynch is excused this afternoon. Mr. Stoffel.
Yes, no questions. Thank you.
Excellent. Ms. Drake.
None for me, thank you.
Okay. And finally, staff.
No questions. Thank you.
Okay. Hearing examiner Ryan.
Yeah, no, I'll join the chorus and also I have no questions.
Well, Ms. Johnson, I don't have any questions for you either. So you win the prize for shortest amount of time on the stand today.
Thank you very much.
Very much for your direct testimony. It was obviously thorough, or else we would have had more questions for you. So thank you very much for your participation.
Wonderful. Thank you.
You are excused. All right, so then we're just going to move on to NMDOJ's witness, Maureen Reno.
I can't, Madam Hearing Examiner, I can't see if she's in the waiting room, but I will call her.
No, yeah, she's not. Yeah, so we can just sit. It's fine.
I mean, she probably thought that was going to take longer. So that's fine. We'll wait. There's Ms. Reno. Israel, I can see that you're on the screen, but you're not on camera yet. There you are. Can you hear us okay?
Can you hear me?
Yes, we can.
Okay.
All right. The witness can be sworn in.
I was competing with my phone.
Okay.
My headset was competing among two different sources, so.
Raise your right hand, please. Can you hear me? Maybe not.
Yes, I can.
Oh, can you raise your right hand so I can put you under oath? Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I don't think she's hearing me.
No, it seems like some audio trouble.
Serena, do you want to do you need a minute to get your technology in order?
I'm not really hearing anything, and I'm not entirely sure why.
Did you have headphones, Miss Reno? Looked like she took some earbuds out of her ears, and sometimes.
Yes, I did. And so I can faintly hear you out of my computer.
Right.
But I'm not sure why I can't seem to increase the volume coming out of my computer.
Did you check? So if you go to your audio settings, the little caret guy, just make sure the speaker is selected to whatever. Like if you have like external speakers.
No, I just have speakers coming out of my computer. It's direct, so I'm not really sure what's happening. I
You have
apologize.
that's okay. No, it happens. You have a pair of headphones you can plug into the headphone jack, or even just
I can hear you now.
You can hear us.
Can you hear me?
I can hear you.
Okay.
All right, go ahead and swear the witness.
Okay, I'll try this again. Can you raise your right hand?
I don't think she can hear you.
Oh, that's weird. I didn't change anything.
No, you didn't. No, it's.
No,
I
we
don't
can
think
hear you.
she.
Okay.
So this is the problem with Bluetooth. I think it's like sometimes the machines have all these varying things that like have to line up. Like your sound card selection has to line up with Zoom's like selection. Sometimes you need the plug-in headphone because then you just override everything.
Yeah, we can either take a quick break or we could see about swapping back because I think we would still probably get to Ms. Reno today. What would be your preference, Mr. Elliott?
I'm good with either. I'm trying to see if Miss Reno's making progress, but certainly if we've got somebody else.
Let's. Can I make a suggestion? Let's just take a 10-minute break. Give her
Okay.
some time, and that
Let's
way
do a
she doesn't
10-minute
feel
break.
she doesn't feel on the spot, you know.
Okay, so why don't we just let's just reconvene at 3 o'clock.
And Mr. Elliott, you might want to stay on and maybe we'll work with Miss Reno or however, just make sure her stuff gets working, and then we'll just check in 10 minutes.
Thank you very much, everybody.
That should be fine.
No
All right.
worries.
Lost everything now. Right.
Maureen, I think I can hear you. Can you hear me?
Oops.
What's the status? I don't see Miss Marino.
Well, let's see if she's able to connect. If not, then
That's okay. I mean, it happens.
yeah.
Is like her machine just crapped out?
Yes.
Yeah.
She's using a Microsoft Surface, and I think it was overwhelmed. Well, I would say we can move to the back of the line.
Be next then. Hearings on Barrett. Who do we get?
Is Mr. Lee available? Mr. McMillan?
I believe so, Your Honor. He said that he was going to be watching the YouTube, so he should be joining shortly.
Okay. If you want
I'll
to let him know he's up.
belt and suspenders.
Oh, there's Miss
Oh,
Reno.
Ms. Reno's in the waiting room. Okay, why don't you hold off on Mr. Lee for just a minute? If Miss Reno's working, let's get her done, and then so have him stand by if you don't mind, Mr. McMillan.
Will do.
Miss Reno, can you hear me?
Doesn't appear.
Miss Reno? Are you hearing us? Maureen?
Can you hear me?
Yes, can you hear us?
I can't hear you. I can't hear you. My computer. I'm using, so I'm just gonna try.
I don't see. Oh, Maureen, can you hear us?
Only very faintly. And
And she's breaking up as well. Why don't we? Mr. Elliott, we've got Mr. Lee in the waiting room. Why don't we give Ms. Reno some extra time?
Okay.
And hopefully she can figure something out. We'll get to her today. We'll make sure.
Okay, thank you.
All right. Good afternoon. Thank you. Thanks for being flexible.
Oh, yeah, no problem. Glad to be here, hearing examiner.
All right. If you would go ahead and swear in the witness, please.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. McMillan, you can proceed.
Yes, Your Honor. Hi, Mr. Lee. Could you introduce yourself, please?
Oh, yes. My name is Jonathan Lee. I'm an associate at J. Pollock Incorporated. I'm appearing today on behalf of OPL.
And did you file testimony and work papers in this case?
I did, yes.
And do you have copies in front of you of the documents that have been marked OPL Exhibits 1 and 1A?
Yes, I do.
Can you identify those exhibits?
Yes, Exhibit 1 is my direct testimony, and Exhibit 1A are the work papers supporting my direct testimony.
And were those prepared either by you or under your supervision?
Yes, they were.
Are they true and correct to the best of your knowledge?
Yes.
Do you have any corrections that you'd like to make?
No, I do not have any corrections to make to my testimony.
And with respect to the testimony, if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Your Honor, I move for admission of OPL Exhibits 1 and 1A.
Are there any objections to OPL Exhibits 1 or 1A? Hearing no objections, the exhibits are admitted.
And with that, Your Honor, we present Mr. Lee for examination.
All right. And Ms. Hardy, did I understand you correctly that SPS has waived cross-examination of all of the interveners' witnesses?
That's correct.
Okay. Mr. Elliott, are you available for cross-examination of Mr. Lee, or do you want me to skip you and come back?
I have no cross-examination. I apologize. Thank you very much.
Yeah, of course. No problem. Ms. Lynch. Oh, she's not here. Mr. Stuffle.
No questions, thank you.
Okay. Ms. Drake.
No questions from me, thank you.
And does staff have any questions?
Staff also does not have questions. Thank you.
Okay. Hearing examiner Ryan.
Yeah, Mr. Lee, so at page 8 of your testimony, lines 5 through 6, despite proposing a demand-based allocation, SPS is proposing to recover the SPS solar project costs.
I'm sorry, you're too fast for me, Mr. Ryan.
Oh, I'm sorry. So so I'll start over. Despite proposing a demand-based allocation, SPS is proposing to recover the solar project costs on an energy basis. I was having a conversation with Mr. Gosh, I can't believe I've just forgotten his name.
Was it Mr. Rura by chance?
Correct, yes, thank you.
Of course.
About this, what seems to be kind of tension between SPS's desire to recover through the rider, which is necessarily, well, has been previously and still is energy consumption driven. But what they're really trying to do here is to sort of mimic what you would normally do in base rates. And the acknowledgement Mr. Rupp, as I understood, had in his testimony, he says, well, there's merit to the point that this is likely better off demand based. But because we're in the rider, we're keeping it energy driven. And then I asked him, is this just some indication that this is not an ideal result, that we would approve this going through the rider? So I don't know if you can expand on that in any way or just have any comments about that subject.
Yeah, thanks for asking. I think I've actually taken an opposite approach, and I think that it's kind of a prime example of why SPS's request is unreasonable. They're essentially attempting to shoehorn in these demand-related costs into a rider mechanism that isn't suited for such cost recovery. As I've explained in my testimony, these are demand-related costs, and if you were to assign these demand-related costs or to allocate them to customer classes on demand and to try to collect these charges through energy, it results in intra-class subsidies because costs would be shifted from low load factor customers to high load factor customers.
Is there any merit to that point that we were discussing there where they were saying, well, when we think about RPS compliance, the customers, regardless of what class they were in, who consume more energy should be paying more for RPS compliance, and then therefore there is some merit to the idea that high load factor customers are paying more. Does that make any sense to you?
I think it only makes sense if you're accurately capturing the types of costs that you're considering RPS related costs. For example, for RECs, which are energy related, I think it still makes sense that they should be allocated and collected from customers on an energy basis. But as SPS has acknowledged today, these resources were acquired for a capacity need, and therefore their capacity resources, the RECs they provide for RPS compliance, are almost incidental to that. And as a result, characterizing the entirety of these resources as energy related is inappropriate. And that's why it would be inappropriate to collect them on an energy charge.
And are you saying that they've acknowledged today, are you referring to the testimony we heard from Ms. Trammell about the 4% going to RECs and the RECs getting banked, or are you referring to something else?
I was referring more so to the fact that these costs were, or these resources were, I guess, identified as necessary to meet SPS's projected capacity need. So that's, I guess, more of a resource planning thing as a whole rather than RPS compliance specifically.
And I think as I was listening to the testimony, if I understood Mr. Rurup and perhaps Ms. Trammell said this, that the resources can have dual functions which exist simultaneously. So even as they're serving capacity, they can also provide RECs. And what is the answer to that?
Sorry, I didn't follow the exact question. I heard the setup, but I missed
No,
it.
well, I mean, I'm not. I could be misunderstanding them. So I'm just asking. I mean, it seems to me at some point, Mr. Rurup described the fact that even if these resources, the 2026 solar projects serve capacity, that they're also going to necessarily be producing RECs that can be banked in the sense of saved for future use. And effectively those two things can exist at the same time. Is that correct, or is that what is the perspective of your client on that subject?
Yeah, I would agree with that that characterization. They definitely do provide RECs, but I think the more important thing to keep in mind was that they were acquired specifically to meet a capacity need. That was how SPS presented these resources in docket number or case number 23-00252.
Hearing examiner Barrett and I were talking at one point during one of the breaks about this idea that, and I guess I'm just not really sure how to ask the question even, but like, is there a problem with the company's position that like, if it's rec retirement, then it's RPS? That's what they said earlier. It said like, we'll be using these RECs generated from this facility in the future. The banked RECs will be useful to us. And I think hearing Sarah Barrett and I were like, well, where do we start to think about when is this really just REC driven versus demand driven? And how do you create a line where you say it's correct to think about this thing as having this function or that function? I understand your point, the point to the resource procurement case, but I guess I'm just wondering, is there some problem just with trying to figure out how is, I think Ms. Barrett asked the question, where do you draw the line? And I guess the commission, I think she and I are sitting here listening to the testimony and trying to figure out how do we correctly draw the line as to what these things are doing and what is the most appropriate way to understand that? And any guidance you can give would be greatly appreciated.
Yeah, I think it's actually, I think the fact that you had trouble verbalizing it, I think attests to how complicated it is. I don't think that there's a clean line necessarily between the costs that are purely for capacity versus these RPS costs. But I think it's kind of helpful to think about the framework of the RPS and the costs that are currently included. And that's that there are these incremental costs for compliance. There are these costs that are incurred specifically because SPS has to meet these state requirements about renewable energy. And I don't think that, in my opinion, I don't think that these SPS solar projects that are proposed for RPS compliance or for cost inclusion meet that criteria because they are serving another purpose wholly.
Mm. Go ahead.
I don't want to
Heard
interrupt
someone-
you, but
No, please go for it.
this just feels like an expansion of our conversation. So then I have two questions. And Mr. Lee, you're a familiar expert witness. We've seen you many times. And you're aware, are you not, that SPS has something of a unique territory, lots of large customers, lots of oil and gas, and in the last couple of years or so, their load demands have grown significantly. Do you think that that's a fair statement?
Yeah, I would agree with that characterization.
Yeah. So I guess my question is just practically speaking, if SPS was in a different posture, and this goes back to Ms. Trammell's testimony about the disconnect between the two timelines, the IRP timeline versus RPS timeline. When these procurements were being proposed, SPS was in a different position as far as RECs were concerned. They are now in a position where they are projecting in the very near future that they're going to be in a REC deficit. So I guess I have two questions. What's the problem with using these resources for both as the need has changed? What do you see as the issue with what they're proposing to do?
Yeah, I don't see that there's, I guess, innately an issue with taking the RECs from the SPS solar projects and applying them to RPS compliance. But I think the more fundamental issue with their proposal in this proceeding is that it's changing the entire nature of the RPS rider. The RPS rider hasn't included any plant costs in the rider itself. And as we heard today, they would essentially be proposing to include all future renewable projects in this rider. I guess that in a sense, this case marks or has the potential to set a very important precedent for how the RPS rider is treated. And to kind of inform how it should be used going forward, I think we should look back and see how the RPS has been used in the past. And the inclusion of these costs, which would normally be included in base rates, is really like a total alteration of what the RPS stands for and what it's currently used for.
So then, to expand on my question, in layman's terms, explain to me what's the problem if for the sake of argument, we say the REA allows for this, that this is not violating the rule or the statute to recover the cost of these projects in the way that they are proposing. What do you see in your expert opinion as the biggest problem with that, with changing the fundamental way that the rider is used to, as the sort of renewable landscape is changing?
Right, yeah. I think that the biggest problem that I see is that it would essentially fast track how these costs for renewable plants are recovered. It would obviate a lot of the normal safeguards that are present in a rate case. If this really is, the future that we're headed towards, in which we're seeing the build out and incorporation of more renewable resources in SPS's rate base, all of those reviews will essentially be kind of fast tracked, and they'll be recovering these costs in these RPS without, I guess, due review and prudence review in a rate case.
Let me ask one question before I forget it. So, Mr. Lee, if we can assume that, and I think this is the case, and I can go back and Ms. Hardy and company will all have an opportunity to talk about this in briefing, but that the initial RPS rider comes into existence in order to track the costs, this incremental costs associated with the necessary renewable energy that was required under the former iterations of the REA, where the requirements were a lot less. There was diversity requirements. It's a whole kind of different animal, frankly. if the idea was to create a tracking mechanism so that the customers could see what is the cost of compliance with the REA, is there any evidence in this case that you're aware of to show that pushing the cost through the rider is going to give the customers a clearer signal as to the cost of compliance with the REA?
No, I think it actually gets muddier because this kind of harkens back to that conversation we were just having. It's very difficult to draw the line between how much of these costs for these resources are associated with its so-called capacity function and how much are associated with this RPS compliance. I think including the total cost of these resources in this rider really obfuscates that kind of incremental cost of complying with these standards.
Okay. And then just one more question, and I'll probably ask all the intervener expert witnesses. As I'm sure you know, there was the commission a couple of years back did explore the idea of just getting rid of the RPS rider altogether. And there was never nothing conclusive came out of that. And I'm just curious, like, what's your opinion on the utility of the RPS rider moving forward as we see these changes?
I don't have an opinion on the continued use of the RPS, but I am familiar that the commission previously considered, I guess, decommissioning the RPS rider. And I think the proposal now is, I guess, 100% counter to that because it would effectively extend the life of the RPS rider, which was previously, considered for, I guess, retirement.
Okay. Thank you. I was just curious about that.
Yeah.
Hearing examiner Ryan, do you have
Yeah,
any?
I do. So I just want to make sure. So we kind of got
take
that
your
on
time.
track there. Yeah. Mr. Lee, could you just explain to me, you make a point at pages 8 to 9, the bottom of 8 over into 9 about two separate reconciliation processes that you see as sort of inherently problematic with the proposal here. Can you just help me understand that a little bit better?
Yeah, I think that this is just one aspect of how much more complicated the RPS rider would become as a result of the inclusion of the SPS solar projects in it. In addition to changing, how the rate itself would be structured if they were to include a demand-related cost, it also incorporates a whole new calculation that also has to be tracked alongside of it. And it changes the structure of the RPS cost rider from kind of this flat fee that's charged the same to all customer classes to become even more complex by having these class-specific rates.
Okay, and so you're saying when the reconciliation, the true-up process happens, the true-up itself would need to be sort of sifted through the varying classes, and that creates complexity that didn't exist previously with the RPS. Is that the point?
Yeah, that's essentially what I'm getting at.
Okay, I just want to make sure. Partly, I'm just making sure I understand what you're writing. That's all.
Right, and I'm thankful that I had the opportunity to clarify that.
Sure. No, it's always a question. That was it. That was all the questions I have, Mr. Lee. Thank you, sir.
All right, thank you.
Mr. McMillan, any redirect?
No, Your Honor.
Excellent. Thank you, Mr. Lee. It's pleasant.
Your Honors.
Oh, I'm sorry, Ms. Hardy.
I apologize. I did have a couple of follow-up questions.
Yes, please go ahead. I
Okay.
kind of forgot about that, but please proceed.
Thank you. Mr. Lee, SPS did request RPS rider recovery for these projects in the CCN case, didn't it?
They did, yes.
And did you hear Ms. Tremel's testimony today that SPS anticipated these resources would be needed for RPS compliance?
Yes, I did recall that.
And based on the evidence SPS has presented here, all of the RECs generated by these facilities will be used for RPS compliance, correct?
That is correct.
And the Renewable Energy Act does not disallow rider recovery for resources that also provide capacity benefits, does it?
That's my understanding.
And regarding the Commission's rulemaking on the RPS rider, it did not decide to discontinue the rider, did it?
No, it did not.
Thank you. Those are my questions. I appreciate it.
All right, thank you.
All right.
I just want to ask, and then it's not, I don't want to get into like an endless back and forth. It's more just the questions Ms. Hardy was asking, raise my own brain questions. Mr. Lee, if you could just comment on this. I mean, it seems to me as the regulator, right? We have a responsibility to exercise some discretionary judgment about how you allow cost recovery, because you're invariably in those moments apportioning risk, producing time consequences, time value of money and all these things. So for instance, on one end of the spectrum, we have the example I gave Ms. Trammell was the securitization of stranded assets or plants that we want to get rid of now in society because they're dirty, the coal plant and stuff. And so there's non-bypassable charges. Well, that's this very definite thing that the utility is going to get. And on the other hand, we have these, rate case moments where it's like, well, you guys have to do projections and try to understand, what are your costs going to be? And that's a lot less clear. And it seems somewhere in the middle is like this RPS thing where it trues up. It kind of guarantees them a certain degree of recovery at all times. And it would seem to me like the task for us is to assess what is the appropriate kind of range of assigning where we should issue the recovery. Is that wrong, or what am I thinking incorrectly?
I think that there is some tension there, as you're acknowledging, because it harkens back to the dual purpose of these resources. They were proposed for a capacity resource, but in this proceeding, they're being characterized as, as necessary for meeting RPS compliance. But I would kind of add on to that. You kind of brought up this idea of uncertainty. And I think that collecting these costs through the RPS eliminates a lot of that uncertainty about cost recovery for these resources, because the fact that the RPS would be trued up would essentially guarantee that SPS would collect its calculated revenue requirement for these resources.
And I think maybe is the point that people are making where we haven't done this in the RPS context before, perhaps an acknowledgement that there's this baseline understanding that there should be some degree of risk associated with production costs because we want to incentivize efficiency?
Yeah, I think that that's correct. If these plants, weren't, if these plants didn't produce RECs, and let's say that they were a combustion turbine or any other generating resource, they would be included in rate base. The fact there would be no, consideration about RPS compliance, and in that case, they'd be considered in a rate case, included in base rates, and SPS would have the opportunity, but not the guarantee, to earn a return on these plants. That risk is all but eliminated in this proceeding if it's included in the RPS rider.
Okay, thank you, Mr. Lee. Ms. Hardy, if you want to follow up any questions I just answered, feel free to do so.
I don't have any other questions. Thank you.
Mr. McMillan, do you have any redirect based on
I do not, Your Honor. Thank you.
Okay. Well, Mr. Lee, thank you again.
All right.
It's a very helpful testimony. Nice speaking with you.
Yeah, it's great to see you again. Thanks for hosting today. I'll see you guys on YouTube.
All right. Take care.
Bye.
Mr. Elliott, status update.
I see that Ms. Marino is still logged in. We're going to try it again.
Ask to start video. Ask to unmute.
Good afternoon, Ms. Reno. Can you hear me?
Yes, I can hear you. Can you hear me?
I can.
Yes, we can.
Very well.
It's good to see you. And
all right.
Hear you.
Third time's the charm. You want to try swearing her in again?
Yes, raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Ms. Reno, do you have what's been uploaded to Dropbox as NMDOJ Exhibit 1 in front of you?
Yes, I do.
And would you identify that for the record, please?
Yes, it's my direct testimony.
And was this testimony prepared by you or under your direction?
Yes.
And if I asked you the same questions today, would your answers be the same?
Yes.
And do you have any corrections that you want to make?
Yes, I do have one question. I do have one correction. On the title page, it should not say rebuttal testimony of Maureen L. Reno. It should say direct testimony.
Thank you. Any other corrections?
No.
Okay. Madam Hearing Examiner, I'd like to move what's been marked as NMDOJ Exhibit 1 into the record.
With that clarification about the title page, are there any objections to the admission of NMDOJ 1? Hearing no objections, the exhibit's admitted.
And I would pass the witness.
All right, thank you. Mr. McMillan, any questions for Ms. Reno?
No, Your Honor, no questions for Ms. Reno from OPL.
Okay. Mr. Stoffel?
No questions. Thank you.
Ms. Drake?
None for me, thank you.
And staff?
No questions from staff. Thank you.
All right. Hearing Examiner Ryan?
Ms. Reno, the Attorney General in these proceedings, along with staff, staff represents the public interest in a whole array of things, but you all also represent, the Attorney General's office represents ratepayers. Is it in the ratepayers' best interest to allow SPS to recover these costs through the rider?
No, I believe not. It's not in the best interest of ratepayers because for quite a few reasons. First of all, we're talking about specifically, well, first of all, my direct testimony is very narrow in scope. I'm specifically addressing the unknowns associated with the new solar energy projects for 2026 and 27. There are a series of unknowns right now in regard to some of the specific costs. Also in regard to what's going to transpire in regard to the tax credits. And there was a lot of discussion on that earlier. Other issues that come into play and came to light today were also in regard to just the nature of some of the other specific proposals in regard to how costs associated with these new facilities will be allocated. I didn't focus that much on it in my testimony, but that I feel that is a concern. And also another thing that I did touch upon in my testimony is just how these costs associated with these new solar facilities will be bypassed in regard to vetted through a base rate case and shoehorned into this rate rider. And from that, we will miss a lot that would typically come to light in a specific rate case that I feel introduces some risk here. And also there is a cost of over recovery associated with the return associated with these costs being recovered through this rate rider. And there was a little bit of discussion as to what the carrying charge should be based upon. I feel that the commission needs to reconsider its policy of allowing a carrying charge associated with this rate rider equal to the rate of return, because what we're doing here in this RPS rate rider and the fact that it's trued up on a very frequent basis is that we're bypassing the review process that the commission would normally undertake. And in addition to that, you're pretty much guaranteeing a stream of cash flow that specifically investors consider credit positive and reduces risk to shareholders. So for these reasons, it's kind of a winded answer, but for these reasons, I feel that recovering these costs of the rate rider is not in ratepayers' best interests.
Do you, as far as, I mean, it's a legitimate question, I'm genuinely asking it to see if you know the answer, but is there any evidence in this case which indicates this is the most affordable path for New Mexico's ratepayers? How would should the commission care? I mean, I think the commission should care about that. I mean, you could pontificate about it as the representative of the ratepayers, but you know, I just am curious, like, well, that would seem to be something we should keep our eyes on, and then the question becomes, would allowing it going through the rider achieve that outcome?
Well, first of all, there are a series of unknowns that, you know, we're talking about facilities, the two solar facilities, one that has begun construction earlier this year. We're still, the other one, Cunningham, I believe, has yet to begin construction. And so we don't know what the costs will be of that project once it begins construction. And so we also don't know, you know, from a holistic perspective, I know there's been discussion about, well, how are the tax credits being considered here? You know, that's part of another proceeding. That's part of the fuel adjustment clause. But, you know, when we're talking about from the interests of ratepayers, we need to take this holistic approach. There are uncertainties as to whether those benefits will accrue to ratepayers. There's also some uncertainty that came to light earlier in regard to the forecasting and the modeling. And then, you know, there's potential distortions about how we even allocate these costs. So I feel like given these uncertainties, it's really an unknown as to whether this mechanism, you know, recovering costs through this RPS rate rider is the most efficient cost reducing way for in regard to the interests of ratepayers. I think I answered that.
You did. No, that's very good.
Okay.
That's all very helpful. I think one of the arguments that the SPS is making here is, if we have this requirement to provide renewable energy, the legislature says we have to do this, we're doing it, we want to comply. It appears as though load forecasts didn't quite capture how much energy we're going to require. So if you guys give us the ability to work through the RPS, get these costs with the RPS rider, this will signal to investors and the world at large that you know, there's a supportive regulatory community for the procurement of these types of resources, which will be useful moving forward. I'm trying to do a great job of sort of, I think you understand like where the testimony describes this. Ms. Trammell does a much better job at that, but is there any merit to that as far as you're concerned?
Well, there's something you said to the end of your question. We were talking about whether or not this is a supportive regulatory environment. And first of all, investors do view New Mexico as having an improved constructive environment from a regulatory perspective. combination of future test year is a big win in minds of investors. A combination of also in regard to how the REA allows for recovery through securitization. I've addressed that in other cases, and that's something that has benefited other utilities in New Mexico. Why not SPS take advantage of that? What I'm saying here is that the supportive regulatory environment does not go away if the commission were to step aside and say, oh, wait a second here, we have a lot of moving parts. Let's consider this through a traditional rate case so that we can have a more holistic approach. We can step aside and say, okay, we have these uncertainties. Let's address it let's consider it in a rate case. Allow for a more transparent process where there's more time for discovery and interrogatories. As part of that process, you would also be looking at cost allocation, and other parties would have more time to reconsider their positions. There are all these moving pieces that that I would see would contribute more to transparency, as opposed to just let's stick this in a rider where the proceeding moves quickly and recovery happens quickly. I guess that would be the ideal in the eyes of the company, but I feel it behooves the commission to really look at this from the perspective of all parties. So you have the shareholders, but you also need to look at the perspective of ratepayers as well, and make sure we're moving forward in a fair and reasonable way, keeping costs under control and also ensuring reliability and all the other objectives that the commission needs to consider.
And I'll just ask you one final question. When I asked Mr. Lee this question, if we go back in time and we think about the rider as being something that was created to allow ratepayers to have a clear sense as to the cost of compliance with the Renewable Energy Act, and as I said to Mr. Lee, I acknowledge we can have discussions about all that history in the briefing portion of this proceeding, but I'm pretty confident that that's correct. I mean, is there any evidence which indicates that ratepayers will be best informed by passing these costs to them through the rider?
Well, to the extent that ratepayers will see a line item on their bill, I think that's very useful information for the customers who understand their bill. I think there's a disconnect there. And it's not unique to SPS ratepayers. It's not unique to New Mexican ratepayers. There is a disconnect. And so we have to look at, how meaningful that line item is, and really try hard to have that line item reflect what's really happening. Company witnesses this morning talked about, well, we need to reflect the costs of building these no solar plants, these solar facilities in the rate rider, in the RPS rider. But would that really tell us all? Because pretty much what we were discussing earlier is that the RPS the REC contribution of these new solar facilities was only 4%. But what we're trying to shoehorn into this rate rider is the total costs of the facilities. And so, granted, that additional line item, is a very useful piece of information, but we need to make sure it's reflecting the appropriate costs.
Hey, thank you very much, Ms. Reno. That's all my questions.
Great. Thank you, Hearing Examiner Ryan. Ms. Reno, that was very informative, and I actually don't have any more questions for you. Ms. Hardy, do you have any questions for Ms. Reno?
I do have a couple follow-ups. Thank you. Good afternoon, Ms. Reno.
Good afternoon.
With respect to customer benefits of rider recovery, per the settlement that's pending in the fuel case, PTCs will be passed through to customers beginning on cost recovery for these projects, correct?
After a year.
I'm sorry, I couldn't hear you.
Yeah, yes, I believe the settlement was clear. And it basically stated that after a year of cost recovery.
That's your understanding of the settlement in the fuel case?
Yes. It delayed. And so the intention was that at this year of delay would give us a better picture as to what's happening. This issue was fleshed out more in that proceeding on the issue of the federal tax credits and what's happening in respect to federal legislation that puts into jeopardy the production tax credit and the investment tax credit. And the fact that SPS is at a net loss in terms of its tax liability would be having to monetize the tax credits associated with the new solar plants. And so these tax credits are even more in jeopardy because of the uncertainties around this federal legislation as to whether or not SPS can even benefit from monetize them and selling them to a third party. So the hopes were that because of this delay, we'd have a better understanding of what's happening in that market as a result of federal legislation. And, at that point as well, your company representatives were expressing to the various parties that we would have a rate case underway and we'd be able to flesh out some of these issues.
Ms. Reno, did you hear Ms. Trammell's testimony today that the pass-through of PTCs to customers begins on the commencement of cost recovery for these resources?
Yes, I heard that, but I also heard as well that there's no guarantee. And so, but the projects would still continue to be constructed because they're needed for reliability purposes. And so what you could potentially have here is these projects being constructed, but customers not receiving those benefits, thereby increasing the burden onto ratepayers.
And thank you. I think you answered my question. Ms. Reno, you mentioned the Energy Transition Act provision on securitization, and maybe SPS could take advantage of that. The provision in the ETA on securitization applies only to coal plants located in New Mexico, right?
That's my understanding.
And SPS doesn't own any coal plants in New Mexico, does it? Do you know?
Objection. Maybe I missed it, but I did not hear Ms. Reno refer to the ETA.
She did actually in response to the hearing examiner's questions.
Yeah, that was a broader dialogue just about the varying mechanisms the commission can utilize to give cost recovery. And I think it goes, within the context of the administrative process, the legislature gives us a variety of different mechanisms by which to pass through these costs. And I think the discussion I was having with Ms. Reno is purely about, the idea that the rider is created, therefore the rider must be used. I'm not sure that I'm convinced that that's true. And so the question I was asking her was, well, the legislature gives us all kinds of authority to do things. And I think ultimately defers to the commission to decide, what in any given context is the appropriate mechanism to allow recovery that will be consistent with the, broad array of stakeholder interests that always come to bear on these proceedings. So, I'm the one who injected the securitization stuff into all of this. I was just picking an example of something that's like, it's a non-bypassable charge, and it's apparently, according to some, more reliable than a T-note, which is kind of amazing. So
So, Ms. Hardy, your question was just whether Ms. Reno is aware of whether SPS has any coal plants in New Mexico. I think it's okay for her to answer that.
I'm not aware.
Thank you. And you mentioned the 4% rec retirement number earlier. And you've heard, though, haven't you, in the testimony today and in SPS's evidence, that all of the recs generated by these facilities will be used for RPS compliance, whether they are retired or banked for future years. Correct?
Well, it depends in terms of, here we have the 4% that would be retired given that 1 year, 2026. But what's going to happen for the remaining 4 years of which those recs can be banked for future retirement? And so, you know, if you're considering a linear projection, 4% a year, that doesn't add up to 100% over 4 years, right? So you still potentially could have some left over. And so what would happen to those recs? It's, I mean, and so I don't think the answer is as simple as you would, as you would present it to be, because we really need to look at the whole portfolio. We need to look at not only what's being provided as a result of the new solar facilities, whether or not they'll even be constructed, and then what recs are they contributing to the overall portfolio. But there is that cap where, you know, in any one given year, you're either you're retiring or you're banking, but you can only bank so much. And each year you can only bank so much.
And Ms. Reno, SPS has modeled the RPS compliance and presented it in this case, hasn't it?
Yes, but through our discussions earlier today, there's some uncertainties around those models. And, you know, whether or not they were going to meet their requirement really depended on what they were assuming.
And your testimony doesn't provide any dispute of that modeling, does it?
No, it does not. As I said in the beginning, my focus was really narrow. It was more or less discussing whether or not the solar facilities would be able to pass tax credits to customers in terms of a benefit. I also talked about, you know, the issues associated with trying to recover these costs through a rider, and how the preferred treatment would be through a rate case. And I also talked about
Ms. Reno, I think you already answered my question. So
okay.
I'm sorry to interrupt, but I object to the witness giving narrative answers when she already responded.
I think that's fair. I'll sustain that.
Thank you. So I have no further questions. Thank you.
Okay. Hearing examiner Ryan, do you have any more questions for Ms. Reno?
Oh, thank you.
And Mr. Elliott?
I don't, thank you.
Okay.
Ms. Reno, thank you for your time this afternoon.
Yeah, thank you very much. I'm glad your technology ended up working because it was very helpful talking to you.
You're welcome, Your Honor, and I appreciate your flexibility.
All right. Have a good afternoon. You can be excused.
Thanks.
All right.
Mr. Higgins is being admitted. It would appear as he is the
Excellent.
next person.
And the New Mexico Large Customer Group would call Mr. Kevin Higgins once he's admitted.
Right. And is it going to be you or Mr. Crowley doing his direct examination?
It will be me.
Great. There's Mr. Higgins. Can you hear us, sir?
Yes, I can.
And we can hear you. All right. You'd go ahead and swear in the witness, please.
You're right. And do you solemnly swear the testimony you are about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good afternoon, Mr. Higgins. Can you hear me okay?
I can, Mr. Stoppel.
Thank you. Will you please state your full name for the record?
My name is Kevin C. Higgins.
By whom are you employed and in what capacity?
I'm a principal in the consulting firm Energy Strategies.
Did you prepare direct testimony on behalf of the New Mexico Large Customer Group in this proceeding?
Yes, I did.
And do you have a copy of that has been marked as Exhibit NMLCG1?
I do.
Was this testimony prepared by you or under your supervision?
Yes,
Do you have any corrections to your testimony in this proceeding?
I do not.
If you were asked the same questions today, would your answers be the same?
Yes.
I'd move to admit hearing exhibit NMLCG1.
Are there any objections to the admission of Exhibit 1? Hearing no objections, Exhibit 1 is admitted.
Thank you. Mr. Higgins is available for questioning.
All right, thank you. Mr. McMillan, do you have any questions for Mr. Higgins?
No, Your Honor.
All right, thank you. Mr. Elliott?
No, thank you.
From NMDOJ. Ms. Drake?
No questions for me, thank you.
All right, Ms. Ruiz?
No questions from staff. Thank you.
Okay, great. Hearing examiner Ryan?
At page 11 of your testimony, Mr. Higgins, at lines 1 and 2 there, you write, and I just want to make sure I understand the point. There are no incremental costs of RPS compliance associated with these projects, as none of the cost is considered to be uneconomic. Can you just, there's been some discussion about this today. I'm not entirely sure that I'm clear on all of this yet. So can you just explain this point to me perhaps in different words, or just give me the simplest explanation you can?
Certainly, Mr. Hearing Examiner. In my view, my recommended policy position for the commission on this subject is to maintain the commission's current policy with respect to the RPS. And that is, the RPS rider is used currently to recover costs for RPS compliance that are greater than the cost of otherwise providing the same amount of energy into customers through the next best alternative, absent meeting RPS compliance. And so what that means currently is that purchases such as the Sun Edison purchase are put into two different buckets, if you will, for RPS compliance recovery. The portion of the Sun Edison contract that is considered to be economic, that is, it's being purchased at what is construed to be a market price, is recovered not through the RPS rider, but it's recovered through the FPP CAC. The portion that is not economic, that is the portion of complying with this statute that costs more than it would otherwise cost to provide the same amount of energy, is recovered through the RPS. And so that is what I'm referring to in this portion of my testimony. And with respect to the new projects, the 2026 solar projects that are at issue in this proceeding, as well as potentially the future treatment of the 2027 solar projects. In the case of those projects, none of those costs are greater than the alternative cost of providing that energy and capacity. That is, they were acquired through a competitive solicitation, and they represent the most economic option available for meeting the utility's capacity needs. Therefore, it is neither necessary nor good policy, in my view, to recover those costs or any portion of those costs through single issue rate making or piecemeal rate making, which is what the RPS rider represents.
That was very helpful. Thank you, sir. I'm just scanning the testimony to see where the questions I have. I think that'll do it for me, Hearing Examiner Barrett.
Mr. Higgins, I actually don't have any follow-up questions for you. Your direct testimony, as always, was very clear and very helpful, and we appreciate you. Ms. Hardy, do you have any questions for Mr. Higgins?
I do not, thank you.
Okay. And Mr. Stoffel, do you have any redirect based on Hearing Examiner Ryan's question?
I do not. Thank you.
Okay. Well, Mr. Higgins, thanks you for being here today. Nice to see you.
Same here. Thank you very much.
Have a good afternoon. You're excused. Let's take a quick 10-minute break. Mr. Gorman is up next. Actually, before we take a break, Hearing Examiner Ryan and I want to discuss, do any of the interveners have any cross-examination for Mr. Gorman? If you do, just indicate it now. If you don't have to say anything. Seems to be the trend. All right.
Madam Hearing
Really?
Examiner.
Yes.
Since we're on the subject, I would request to be excused for the remainder of the afternoon.
That's fine, Mr. Elliott. Thank you.
Thank you very much.
Let's just take a 5-minute break, actually. Let's come back at 4:05, please.
What's the temp there, Miss Gonzalez, in the Arizona land?
Oh, I don't know.
Does your computer tell you? We got 89 here in Santa Fe.
I'm jealous. No, I'm sure it's 110 or something. It's really bad. Yeah.
I was telling Miss Barrett, I was out, on our breaks, and I ran to one of the folks who works here. I was like, oh, it's hot. And he's like, oh, it's not too
No.
bad. And I got back to the computer and it says record-breaking heat. And I'm like, yeah, it's hot.
Oh, for you guys?
Yeah, apparently here in New Mexico too, this today's temperature is records for the day, I think. This is kind of
Yeah.
early to mid-June, right? Or I guess mid-June at this point.
Actually, this is pretty typical for here.
It is 101 in Albuquerque.
Oh man.
Did you say it was
101
89 in
here, too.
Santa Fe?
It's 89
yeah.
in Santa Fe. It's hot. For sure.
All right. Okay.
Back on?
If everybody's back, we can go back on the record. Ms. Drake, none of the interveners have any cross-examination for your witness, and hearing examiner Ryan and I don't have any substantive questions for him. So he can be excused from the hearing. Is there any objection to admitting LES Exhibit 1, which is Mr. Gorman's direct testimony as though he appeared here today? Hearing no objections, we will go ahead and admit LES Exhibit 1 to the record as though Mr. Gorman had attended the hearing. And you can let him know that he is excused, Ms. Drake.
I will, thank you. I'm sure he'll be sad to have missed you all, but thank you.
Hopefully we'll catch him next time.
Yeah.
All right. So we've got 2 witnesses left, and that would be our staff witnesses. And my understanding is that Ms. Acosta is going to be up first. And who's going to be doing her direct? Oh, are we going to be doing? I thought we were swapping them.
The swap would be to have Miss Alicia Leyva-Tesoro to go first.
Okay, I already changed it on my paper and didn't realize I had gotten ahead of myself. So Miss Leyva-Tesoro, and I see she's here. Hello, Miss Leyva-Tesoro, can you hear us?
Yes, I can. Good afternoon.
Good afternoon. Miss Gonzalez, can you swear in the witness, please?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Thank you.
Good afternoon, Ms. Leyva-Tesoro. Could you please state your name for the record?
My name is Elisha C. Leyva-Tesoro.
And how are you employed?
I'm the Economics Bureau Chief in the Utility Division of the New Mexico Public Regulation Commission.
And as part of your duties, did you review SPS's requested approvals in the present matter?
Yes, I did.
And did you prepare testimony for this proceeding?
Yes.
Do you have a copy of what has been marked as staff's exhibit number 1 for you?
Yes, I do.
And what is that?
That is my prepared direct testimony that was filed in this case on May 21, 2025.
And was this testimony prepared by you?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
And are the answers true and accurate to the best of your knowledge?
Yes, they are.
Does your testimony have any attachments?
Yes, it does.
Attachment, what has been labeled attachment ELT1 to your testimony? What is that?
That is my case experience list.
And is there another exhibit? Sorry, attachment?
Yes, there is. It's responses to discovery requests.
Do you mean staff's discovery request to SPS?
Yes.
And let's see. Staff moves to admit what has been labeled staff exhibit 1, including the internal attachments to the record.
Give me just a second. Ms. Lang, do the attachments, which are the Am I understanding that at least one of the attachments is a discovery response? Does it include the full question and response?
Just the ones that we are moving to admit, Your Honor.
Okay. But what you're moving to admit does have. Okay. Are there any objections to staff exhibit 1? Hearing no objections, the exhibit's admitted.
And I pass the witness for cross-examination. Thank you.
Thank you. Mr. McMillan, do you have any questions for Ms. Leba Tesoro?
I do not, Your Honor.
Okay. Mr. Elliott has been excused. Ms. Lynch has been excused. Mr. Stoffel, do you have any questions?
No questions. Thank you.
Ms. Drake?
No questions, thank you.
All right. Hearing examiner Ryan.
Ms. Libertacero, at page 28, lines 7 through 11, you note what the percentage increase would be for the rider by including the costs of the 2026 solar projects. And the last sentence there on that paragraph of writing is, this change could result in customer confusion and potential complaints. And I'm just sort of reflecting on that statement in light of the questions I've asked other witnesses today. I think your point there, I mean, if I understand correctly, is, you know, if the rider mechanism and the whole purpose for its existence was to keep the ratepayers abreast of what they were having to pay in order to comply with the REA. And maybe you'll just correct me if I'm just misunderstanding what you're saying, but it sounds like what you're conveying there is that sort of a large increase isn't going to be understood, and that's not desirable.
Yes, that's part of it. Not only the large increase, but the change in the structure of the rider and going from one charge for all customer classes to a different charge for each customer class. So all of those things together, yes, I think they can cause customer confusion. And I think that, you know, as we are in a different environment now than at the time SPS's RPS cost rider was established, and renewables comprise a larger percentage of utilities portfolio. And so I think in general, we're starting to see more sizable investments to meet RPS compliance. And so it becomes more important to look at those costs, and particularly these costs of the SPS solar projects, because they were proposed to meet capacity needs. And so it's important to look at those in the context of a rate case where we can look at those costs holistically and get a more complete picture as affordability becomes a more and more of a greater concern. And so we need to look at those costs and how they're impacting our ratepayers, and to help us to make better decisions as to how to allocate those costs among customer classes, and to address issues like cross-subsidization, which were issues raised by some of the interveners in this case, and things like banding to help mitigate the impact on particularly our residential and low-income classes, and to be able to implement rate structures such as low-income rates, which are now allowed to be proposed by our utilities under recent legislation.
And there was some testimony in this case by a variety of different witnesses about the rulemaking where the rider was discussed by the commission, and that rulemaking or the changes to the rule never happened. It just sort of fizzled away. But did staff have a position in that proceeding as to, like, when it was advising the commission what Did the staff ultimately agree with some of the quoted material we see in the testimony in this case? And I don't, hopefully I'm referring to, like, there was some block quoting that was occurred in some of the testimonies about what the commission had to say about the RPS rider, what utility it serves in a more heavily renewable driven system. I'm just curious if staff has a position on those matters.
Yes, and staff has historically been supportive of the RPS rider for transparency reasons, but staff recognizes the commission's concerns in that case. And I provided that information on the 2158 case in my testimony as well, because I think that it's very important to consider the commission's concerns regarding the continued use of RPS riders, especially as staff. I believe I'm obligated to not only consider the statements, the precedent set by the existing commission, but the concerns, statements, and precedents set by prior commissions. And while the final order in this case that addressed the concerns of a prior commission, but the majority of the existing commission, they issued the last order that was issued in that case. And that order indicated that the commission intended to go back and revisit these issues on the RPS rider, that in due course, the commission would issue a notice of proposed rulemaking to address these issues. And that docket remains open and pending under our current commission. So those issues are still unresolved. And so I question whether we want to add complexities to the rider and expand the rider when we're uncertain about the future of RPS riders.
If we this is purely hypothetical and no suggestion as what we're going to decide here, but I'm just trying to understand if we were to grant SPS's request for recovery through the rider, would that effectively resolve those issues in that open docket?
Would it resolve those issues?
Meaning resolve it in favor. I'm trying to understand what's the consequence of what we're doing here in relation to that docket that you point out remained open. So the commission said they do something. Does the decision in this case basically answer that? I mean, are we kind of like, we're deciding that docket just in another docket?
So you mean if the commission were to approve SPS's request here, are they then indicating that we should continue the use of riders? I suppose that it could be interpreted that way, but there were other issues to be addressed in a future rulemaking, such as line loss adjustments. And then in this case, we're bringing up allocation issues and potentially having demand components in riders, which to my knowledge, none of the 3 investor-owned utilities have in their RPS riders currently.
Well, it's interesting too that the fact that it was being handled in a rate making, I don't know that I've considered that part yet. It's like, should there be uniformity among the utilities as to how they proceed with these RPS cases and what can be done there? And what extent is this best adjudicated in a rulemaking, or is it appropriate for individual adjudication in a case like the present? Any thoughts about that?
Yes, I believe the most appropriate place to do that would be in a rulemaking where all stakeholders can weigh in, and as you said, there would be consistency among utilities in how they handle these issues going forward.
I'm just scanning through the testimony to see my notes. That was all the questions I had for Ms. Lieber-Chisero. Thank you very much, ma'am.
Thank you.
I'm trying to formulate one question. And I may not have all of the information that I need. In her testimony, Ms. Trammell referred to a prior case in which, in her opinion, the commission approved 2 utility-owned resources of PNMs under the RPS rider. And I'm sorry, and I I can't find exactly where it is. But you read Ms. Trammell's testimony?
I did, yes.
Are you familiar with these cases that she was referring to? And if so, what differentiates that from what SPS is asking for in this case?
And Ms. Barrett, I don't know if that's page. I just did the control F on Ms. Trammell's testimony. She's page 33 of her direct. She talks about in PNM's 2020 RPS filing, the commission authorized recovery of the cost of a 50 megawatt 2019 solar voltaic project through the rider. That's which one you're referring to?
That's exactly it. That's
Yeah,
exactly.
so that's page 33 of Ms. Trammell's direct. Might be referenced in the rebuttal too, but I don't there.
Okay. In your work with the commission, are you familiar with those cases or that case and those approvals? And if so, what's the difference between that and what SPS is asking for today?
I'm somewhat familiar. I did not participate in those proceedings, but my understanding is that those resources were procured for RPS compliance purposes. They weren't capacity resources.
When you say they were procured for RPS compliance reasons, were they included in an IRP?
I don't know.
Okay. And when you say, and this goes back to the great explanation Mr. Higgins gave, when you say they were procured for RPS compliance reasons, what that means is that 100% of the cost of those would have been considered non-economic?
I think SPS has a different way of recovering its cost through the rider than possibly the other utilities have, so that may not apply there. But in this case, I see, these resources, the cost of these resources would exist regardless of RPS compliance. SPS has indicated that it needed these resources to meet capacity needs.
Okay. That's helpful. Thank you. I appreciate your answer. Okay, that's the only question that I had for you. Thank you for your testimony.
Thank you.
Mr. Purcell, do you have any questions based on what we've asked?
Yes, just a couple. Ms. Labatacero, based on your testimony here today, is it staff's position that the self-billed solar costs should be included in base rate so that the commission can consider a gradualism adjustment of SPS's generation revenue requirement among customer classes?
One of my concerns is that these costs should be considered holistically in the context of a rate case, but that's not my only argument against recovering them through the rider. Those arguments are set forth in my testimony. The rider, as currently established, does not authorize SPS to recover these costs. The rider was established to recover the incremental cost of RPS compliance, which the solar resources are not. They do not fall into that category.
Okay. And to follow up on that, in general, do you agree that class allocation inclusive of a gradualism adjustment does not reflect true revenue responsibilities by class?
Yes, I agree with that. But in setting rates, there are other things that we need to consider, including ability to pay.
Understood. Thank you. That's all I have.
All right.
Hold on one second, actually.
Sure.
Okay, a couple more. Well, just, going through my notes. Is it your position today that for the recovery of costs related to the solar projects or any project, that it has to be 100% solely for RPS compliance to be recovered through the rider?
No, but I believe that in the current environment that we are in, that it's in the public interest for those costs to be addressed in base rates rather than through the rider.
Okay. And if SPS didn't use these resources for RPS compliance, would it be staff's position that SPS would have to go out and procure additional resources separately from its capacity requirements to comply with the RPS increasing requirements under the statute?
If SPS did not use these resources for RPS compliance, well, if SPS has these resources, I'm not sure why they wouldn't use them for RPS compliance. But if you didn't have them, then yes, SPS would have to procure additional resources.
Okay. And just to be clear, you're saying that in order to be incremental, it had 100% of the resource has to be eligible for the rider. Is that what you're saying?
Yeah, in this case, SPS is proposing to recover the entire revenue requirement associated with the SPS solar projects through the rider, and that does not classify as an incremental cost of compliance.
Okay. Thank you, Ms. Lebatissero.
Thank you.
Examiner Ryan, do you have any other questions based on Mr. Purcell?
That was an interesting reference to gradualism. So I guess, Mr. Lebatissero, I'm not sure if I understood Mr. Purcell's question entirely, but the question, it seems a pertinent one, which is like, if the concern you have is, as articulated in your testimony, is that 252% increase will confuse ratepayers, is it because it's so large? And is it true that if we were to push these things through base rates, we would be more likely to find ways to diminish that type of an increase?
You're taking other factors into consideration in a rate case that we are not in an RPS rider, and we already have so many riders out there: transportation electrification, grid modernization, energy efficiency. And I think it's just becoming more important for us to look at costs more holistically so that we can get a true understanding of what the impact of all these costs are on ratepayers, and to be able to better determine how to allocate those costs based on those impacts.
Okay, thank you. That was all. The only thought I wanted to ask.
Ms. Lang, do you have any redirect?
I do not, thank you.
All right. Well, thank you very much for being here. We appreciate your testimony, and you are excused.
Thank you.
And our second staff witness and final witness is going to be Ms. Acosta.
Let me contact my witness and have her log in.
Ms. Lang, she's in the waiting room.
Thank you, Your Honor.
All right. I see Ms. Acosta on the screen. Can you hear us?
Yes.
We can hear you. All right. Please go ahead and swear in the witness.
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good afternoon, Ms. Acosta. Could you please state your full name for the record?
Elizabeth Acosta.
And how are you employed?
I'm a public utilities economist in the utility division of the New Mexico Public Relation Commission.
And as part of your duties, did you review SPS's requested approvals in the present matter?
Yes.
And did you prepare testimony for this proceeding?
Yes.
Do you have before you what has been labeled Staff Exhibit 2?
Yes.
And what is that?
It is my prepared direct testimony filed in this hearing or this case on May 21st, 2025.
And was this testimony prepared by you?
Yes.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
And are the answers true and accurate to the best of your knowledge?
Yes.
Staff moves to admit what has been labeled Staff Exhibit 2 into the record.
Thank you. Are there any objections to the admission of Staff Exhibit 2? Hearing no objections, the exhibit is admitted.
And I pass the witness for cross-exam.
All right, thank you very much. Mr. McMillan, any questions?
No, Your Honor.
Mr. Elliott's gone. Mr. Stoffel?
No questions, thank you.
Ms. Drake?
No questions, thank you.
All right, hearing examiner Ryan.
Just one, Ms. Acosta, at page 3, lines 13 through 19. Question is, are there other riders besides the RPS cost rider established to recover the RPS costs? And then you reference case 23-230 and explain that the commission approved the discontinuation of the previous RPS reconciliation rider at the end of 23. And I'm just trying to understand the point of this reference in this test. What is this? What is the point of referencing this? And I'm not asking that to suggest there is no point. I just want to make sure I understand it.
Just to provide history of the RPS rider.
Okay. That was all the questions I have.
And that was actually the same question that I had. So I don't have any more questions for you, Ms. Acosta. Mr. Purcell, do you have any questions for Ms. Acosta?
No.
Okay. And Ms. Lang, any redirect based on hearing examiner Ryan's question?
No, thank you, Your Honor.
All right. Well, Ms. Acosta, thank you for your testimony. It was very helpful. Thank you for being here today.
Thank you.
And you are excused. All right. Unless I am missing something, hearing examiner Ryan, that concludes the evidentiary portion of this hearing.
Yep.
All right. So during the break, hearing examiner Ryan and I were discussing briefing. We will be issuing a briefing order. We do both have specific questions that we would like addressed in briefing, but we feel like it's the end of the day and they will be better articulated in a written order. And we will endeavor to get that out to you as soon as possible, hopefully in the next couple of days. Unless the parties want to shorten the briefing timeline, we will just follow the normal course of briefing and the normal timeline. I've never heard anyone want a shorter timeline, so I'm going to assume that we're good with that.
Well, and part of this is the compressed discovery schedule and all these events occurring faster. So often we found at the end of the day that the briefing process gets compressed. So part of the upfront pain we all suffered is now, we have the actual time allowed by the rules to do this post-hearing stuff.
Yeah. And expanding on what hearing examiner Ryan said, I just want to say on the record that at SPS, you were the first, this was the first RPS case to have this compressed schedule introduced. And you all did an extremely impressive job. Today's hearing was really great and very informative. And so we appreciate that you were able to turn it around so quickly and come in and have what I consider to be an extremely helpful hearing. So thank you very much for your cooperation. Hearing examiner Ryan, what else?
Unless there's anything else from the parties, I don't think there's anything for me to say. But the brief, so the transcript, Ms. Gonzalez has 10 days. My suspicion is a single day hearing will take less than that. And then thereafter, the clock starts ticking for the briefing thing. But Ms. Barrett and we'll get an order out, just memorializing the dates and everything.
Yes.
And in the event we discover there is some sort of time compression problem, we'll identify that in that order. Anybody can file something if need be, but I think we should be fine in terms of the timing.
I think so too. Anything further from the parties? Well, thank you again for a constructive and efficient hearing. And this hearing is adjourned.
Hold on.
Good afternoon. Oh,
I
Ms.
have one
Gonzalez.
question. The Miss Trammell's exhibit that was corrected, that is up already. We decided.
That is, yeah.
Okay,
and
I
the
gotta
way
go get that.
No, it's fine. It was all there. It's this. So Hearing examiner Barrett and I were like sort of joking about this. Dropbox is not. We don't do Dropbox because we love Dropbox. It's just the best thing we could find.
Yeah.
So when you name it, so it was all SPS something, and then it was corrected, blah blah blah. So it didn't show up in the title. So I chopped out, I deleted the initial filed one and just left SPS ones there. So that's the only one that's there at this time.
Okay, I'll go get that one. That was my only question.
Yep.
Okay.
Great.
Thanks, guys.
All right. Thank you very much, everyone. Enjoy the rest of your day.
Thank you.
Bye.
Thank you.
Sure. Bye.
All right.
Thank you.
Bye.